So Lace Christian was reset to win. On Lace Christian?
Ryan Gertz on the murder case.
Yeah, I know.
And Mr. Johnson on the.
Where's Mr. Johnson?
Remember, Judge, you.
His dad's in the hospital.
Yeah. So what did we reset this to?
We didn't. I need to get with Mr. Johnson and Mr. Gertz to see when they both have a free week because it's the two separate attorneys.
Yeah, we gotta figure out who's gonna go so we can work one of them out.
Yeah, we got to figure out pretty quick. It's old,
Yeah, I understand, Judge.
really old. So when are we going to figure that out? When can we get together with everybody?
Well, I was going to send an email to everyone
Let's do that.
and CC everyone and see.
Does the state have any preferences? Everfield?
These are resolved, Judge. Will be pleased.
Okay. And Adria Richard. Richard? Adria Richard?
Judge, that's not a trial. That's just a probation status hearing.
Why is it on the trial docket?
Oh, no.
Why is it on the trial docket?
No, I'm talking about you.
Please fill out the Apple Card link. Don't remember.
And this person's on probation, right? It says this is set for the last event was June 24th. I don't have another. Setting it all. We have some. Find out why in the world it landed on the trial docket, please.
The resetting says at the hearing, so I'm not quite sure.
It's a status,
Yeah.
like a review of probation.
Yeah.
But how did that make it?
Yeah, I'm not quite sure how.
David Tovar.
We're ready on understand the special savings laws.
Ms. Tom? Lance Dixon? Hey, let me ask you.
Smart.
Lance Dixon?
Yes.
Tom Burbank? Not here. Are you Lance Dixon? Just have a seat. Have you seen your lawyer? Call Mr. Burbank. He's invited to come to the trial document. Steve Matlock?
There you go.
Cedric Feynman?
Mr. Burbank informed me that I was going to do the plea today.
Is Mr. Burbank around by any chance?
Right.
Am I in the wrong place? Am I in the wrong room?
I think Burbank might be. We'll find him.
Yeah, it's not.
Ricky Sloan.
Ready now. Classic. That's fine.
So my judge.
I had a Ricky Turner. I apologize. Ricky.
Yeah, that team is filed. This one I had a death event last week. I'll be leaving.
Where was going on? Where we headed on?
Actually, pretty close to getting to the
Yes,
death.
I mean.
I'm trying to.
Yes, sir.
We got it. I think it's gonna make it that. Yeah, we can give me 3 weeks.
Okay, I'm just going to set 3 weeks. Okay.
Thank you.
We said 3 weeks on Sloan's 2 cases at the agreement and request of the parties. Thank you. Wyatt Willoughby. Right.
He's present, Judge. He's outside. May I ask the court to move this to another setting, please, Jim? Good.
Let's see. She's kind of busy. Sounds like I think you are. Well, we're headed on this. You just All right. At the end of that conversation, here's what we're going to do. Reset 4 weeks for a final fish or cut bait disposition one way or the other. Okay? 4 weeks. Thank you, everybody. I was sick. And I had a burst appendix. The only time I've ever been in Boston. Christopher Watson, Langston, is that the one that's,
It's gonna plea judge.
and Ronald LeBeau, John?
Ready. Ready.
Okay, let me see the parties on this one, please. Just real quick, thanks. So, you didn't get to go out off your food? Not mine. All right, here's what we're going to do. Y'all ready? The tree. Something else we get tried. Both of us. You didn't get anything but trial. Sure. Okay.
All ones of
All
that.
right.
This is one of Sonny's cases, but I've got a ready judge.
You think so?
There.
Okay, Will Duncan, Langston. On Jimmy, and what did Langston have to say on Mr. Duncan?
We can go back and forth, but I don't know what his final decision is.
Have a seat. Yeah, we don't want you up here without your lawyer. I don't know where he is.
Might be in the back, Judge.
He's in the back. But you're Glenn Duncan. You're here. Y'all don't know.
I don't know what his
All right.
final decision is.
Marvin Parker.
Ready. I'm not ready.
Ready on that as well, Judge.
It's
And Tommy Williams.
don't take it. Whichever one you choose.
Ken Bailey. Langston.
It's supposed to be Jim, but that was a typo.
It's supposed to be who?
Jim Bailey,
Oh,
typo.
no, but that's Langston.
There's some, well, Langston gets here, there's some motions to quash some subpoenas on those that we need to talk about. Oh, where Langston, you know.
Ricky Turner.
This one.
Ricky Turner.
We need to be.
That's ready. John.
Ready, Your Honor. Yeah, ready. Thanks.
All right. Hmm. All right, on Everfield, the lawyers, come on up, please. If you'd be so kind. That's Tom Kelly. Tom, where you go? You went. On Tobar, Mr. Wilkerson, you and Sarah. Come on up, please.
You sign people like that.
Thank you.
We have Tom, Your Honor, if you want to,
You have one?
Tom, if you want to talk about that.
Which one are we trying to get at? Which one did you need to try?
Oh, Tovar.
So that's going to be done
Okay,
on time, so.
that's gonna be a plea on Everfield, I believe.
Okay, David Tovar's one. Stand by. Two is, Sarah, if that happened to fall through, is Stephen Matlock ready?
I could do Stephen Matlock if I needed to, Your Honor. Yeah.
Okay, two. Um,
I didn't even put it on top of it.
and Marvin Parker. Yep.
Okay.
Ronald LeBeau. On Ronald LeBeau, John?
Yes, sir.
And Mr. Ham? On Ronald LeBeau, I'm gonna send that to, Judge Wortham.
We can't do that for two reasons, Judge.
Oh, that's a jail.
Yes, sir.
Ricky Turner is Ricky Turner. That's who I'm going to send. Daniel.
Been in communication with Judge Rankin in regards to a different case to try to get moved over there. They do not have a jury panel anymore. Something came up with him.
She just told me to send the other.
I have an email that canceled it, Judge.
Hey, when did we get this thing from Judge Wortham that they could handle the case? They said no, they don't have it. They don't have a jury.
That's the last thing I heard on Friday.
Oh, I wasn't here on Friday.
You didn't hear that from them this morning? About they're ready to handle?
If they let us know Friday, I wasn't here, and then I was prepping everything this morning at the.
My understanding is something came up for Judge Wortham, you know.
My apologies, Judge. I didn't.
That's okay.
You dismissed an election. You dismissed it. You said he did.
Okay, so we have Tovar, Matlock, and Jimmy, did you say y'all could do LeBeau?
Yes, sir. I also have Dixon ahead of that, Judge, if you want to consider that. You want to put it on the tablet, everybody knows.
I didn't see Burbank though. I don't know what the word is on him.
Yes, sir. I just want the court aware about that.
Okay.
Nothing to Mr. Burbank.
Tovar, Matlock, LeBeau, Dixon, reset on Christian.
So it got from another trade.
It's whatever date that we were all here, the voting of the town. And it was certainly don't we say it's 450.
Hey, do we have any other?
Another trade.
Do we have any other civil district judges? Do we have any other civil district judges who?
Today, Judge.
All right, trial.
For them. Everybody else in trials.
Everybody else is in fun. All right, then that's the lineup for us. Others are pleas or resettings. Okay. Who's ready on the queue for pleas? Do we have anything? Yes, no?
Yes, we're working on stuff.
Our clients that are online that did not get paid every go.
Yeah. On, and LeBeau, that's a trial. That's going to be a trial. I'm not accepting an agreement on any sort on that one. That's going to get tried. Also, hey, John, Ricky Turner as well. No deal on Turner. Does he have a resetting?
We're sitting now on time.
I'll John, but I just.
Okay.
Learning with people.
Langston, what do you have?
I got the plea off the trial docket. That's gonna be Mr.
Is it ready?
It's ready.
Who is it?
The Caleb Watson.
Christopher Watson.
I mean, sorry.
Or Christopher.
Christopher Watson. I said Caleb by mistake. Christopher Watson. He's ready to be ready. And he's on the trial docket.
Okay. Here, oh, all these other fellas. Is it in the back?
He's back.
We need Christopher Watson, please. Thank you.
You might have to give you my tablet. Yours is updating, so.
We have the new tablets now? We'll never get that. That's my bet. That's the line on Las Vegas. We'll never go.
Very pessimistic. Yeah.
Yeah. It's realistic, not pessimistic. It's realistic. Yeah. Does he need to?
Yes.
You need to fingerprint. Thank you.
Please raise your right hand for the record. Have the people who have got the stuff you got. Keep up your right fingerprint. Hold the oh, flat, just a minute. I can get it one more time. I need you to, that'll be same one.
All right.
The same, the right one. It has to be flat. Can you roll it, okay? Because I've got to see it.
No, it's really.
Okay.
23 CR 1254 is called State of Texas versus Christopher Caleb Watson. That's you, sir? Yes, speak out so she can take everything down. That's you,
Yes.
Christopher Watson. You're here with your attorney and the state's attorney. Mr. Adams, does the defendant waive a formal reading of the indictment and the arraignment here? Can we proceed in summary?
Yes, sir.
In summary, this indictment alleges that on or about April 25th, 2023 in Jefferson County, Texas, you committed the state jail felony of burglary of the building. Do you understand fully what the indictment states?
Yes, sir.
If convicted of such a crime, you face confinement in a state jail for any term of not less than 180 days or more than 2 years. In addition, a fine may be assessed not to exceed $10,000. Do you understand?
Yes, sir.
An agreement's been reached in your case where you would be pleading guilty, sentenced to 18 months in the state jail, and will be given credit for all time served in accordance with that particular case. Do you understand?
Yes, sir.
If I follow this, you have no right of appeal of your case. Do you understand?
Yes, sir.
That's incredible.
Okay. You know, that is good.
It's not right. It's not right. You're right. It's not. So read this. I'm not kidding. It's doing something weird. Look at this right here. There you go. Y'all saw me. I tried to write no and it wouldn't write. And then,
Third time's a charm.
when are we getting the new pants again?
October.
This year?
October 1st. Well, they're going to order them October 1st.
If I follow this, it's incredible. Like I'm in the Indy 500 and I've got a Volkswagen Beetle in the race. If I follow this agreement, you have no right of appeal. Do you understand? So, again, how do you plead to this indictment, guilty or not guilty? You're pleading guilty today voluntarily, and because you are guilty? Question?
Yes, sir.
I show you what's marked as State's Exhibit 1. Did you sign that document voluntarily?
Yes, sir.
Understand it, discuss it with your attorney, or the contents all true and correct?
Yes, sir.
State's Exhibit 1 tendered into evidence.
No objection.
Without objection admitted. Among other things, this states you are mentally competent to enter your guilty plea. It's freely and voluntarily made. You know what you've been charged with in the indictment from wrote to you. You've read it. You were guilty of the crime charged in any lesser included offenses. You are giving up your rights to a jury's trial and the rights to the appearance, confrontation, cross-examination of witnesses. You're totally satisfied with the representation provided by your lawyer. All of this is true. It states so help you God.
Yes, sir.
States Exhibit 1, made it part of the record for all purposes. Pre-sentence report is waived here.
Yes, sir.
I will follow this agreement, sir, and I will make the findings that you are, Mr. Watson, pleading guilty voluntarily, knowingly, intelligently. You were mentally competent to be able to do that. You understand and appreciate the consequences of pleading guilty. There is sufficient evidence supporting your guilty plea from State's Exhibit 1 here admitted to find you guilty beyond a reasonable doubt, and I so find you guilty beyond a reasonable doubt of this state jail felony. I am following this agreement. You were hereby sentenced to confinement in a state jail for 18 months, and you will be given all credit for time served in accordance with this case. Do you understand what has happened to this? Anything else on this? That is all. Thank you.
Thank you.
Yes, sir. Hey. Wait, I haven't seen you since search. You say where? You're wrong. I'm not kidding you.
Yours is almost done updating, Judge, and I can give you. So it's good to go.
Yeah. Who's up next? Please, anybody? At all? What's your
Bill this way.
We'll go, Jeff.
Dariante, Everfield?
I know that. We're moving the room.
There's two cases. One's going to be dismissed.
We're pleading to both, Jim.
Yes. Yeah. But I must have not. Here, give me that tablet, Judge.
No, I need.
You what?
I need.
Oh, we need the file.
Yeah. Everfield.
So one set of plea papers when I had to do that tablet.
No,
But if you'll
I just got the murder.
log in and see if the other set's there.
And Your Honor, we'd also request that tomorrow morning we be allowed to, the family members be allowed to do an allocution on this case. Just give them time to get here from tomorrow morning before everything starts. We could just get it.
Okay. So raise your right hand, you swear or affirm to the people with whom you give up yourself to God. Think of your next on friend. Wait, so flat right there. Think of one more time. It's a flat right there. Just need to adjust.
22-39802 is now called the State of Texas versus Dariante Kelvin Everfield. That is you, sir?
Yes, sir.
Present with Mr. Kelly, your attorney, and the state's attorney.
Yes.
Does the defendant waive a formal reading of the indictment and the arraignment here? Can we proceed in summary?
We waive full reading, Judge.
In summary, this indictment alleges that on or about April 14th, 2022, in Jefferson County, Texas, you committed the first-degree felony
This is yours. It's
of murder by shooting the victim with a deadly weapon, namely a firearm. Do you understand what you were charged with?
Sir.
If convicted of a first-degree felony, you face a term of life imprisonment or any term of not more than 99 years or less than 5 years in prison. In addition, a fine may be assessed not to exceed $10,000. Do you understand the punishment range applicable?
Yes, sir.
An agreement has been reached in your case. If you would be pleading guilty, sentenced to 10 years in prison, is that your understanding of the agreement?
Yes, sir.
If I follow this, you have no right of appeal of your case. Do you understand?
Mine.
Yes, sir.
So moving slowly today. How do you plead to the allegation of murder in this indictment, sir? Guilty or not guilty?
Yes.
Are you pleading guilty voluntarily and because you are guilty?
Yes, sir.
I'm going to show you what's marked as State's Exhibit 1 there. Did you sign that document voluntarily? Understand it? Discuss it with your attorney, Mr. Kelly. Is everything true and correct?
Yes, sir.
State's Exhibit 1 is tendered into evidence.
No
And
objection.
it's without objection, it's admitted. Among other things, sir, the states you are mentally competent to enter your guilty plea. This is being made freely and voluntarily. You know what you've been charged with, and the indictment's read to you. You've read it. You were guilty of the crime charged in any lesser included offenses. You are giving up your rights to a jury trial and the rights to the appearance, confrontation, cross-examination of witnesses. Totally satisfied with the representation provided by your lawyer. All of this is true. It states, so help you God.
Yes, sir.
States Exhibit 1, it's made a part of the record for all purposes. Is a pre-sentence report ready to?
Yes, please, sir.
I will follow this agreement. Anything else to add on that? If
Not on that case, Jim.
Just Your Honor, was requesting the allocution be allowed for tomorrow morning.
Yeah.
But
but anything else to add on this?
No, Your Honor. No.
Okay, if nothing further, I will make the findings that Mr. Everfield, you are indeed mentally competent to enter your guilty plea. It's being made freely and voluntarily. You know what you've been charged with here. It black. It went black. You know what you've been charged with. The indictment's been read to you. You've read it. You are guilty of the crime charged in any lesser inclusion of it. Just, you are giving up your rights to a jury trial and the rights to the appearance, confrontation, cross-examination of witnesses. Totally satisfied with the representation provided by your lawyer, all who so help you God. State's Exhibit 1 is made a part of the record for all purposes. Anything else to add?
Not on that case, Jim.
All right, I'm going. Do you understand what has happened today, sir? Okay. The only other additional finding the court is going to make is that the judgment shall reflect affirmative finding that a deadly weapon, namely a firearm, was used in the commission of this offense, and that will be reflected in the judgment. Do you understand? Anything else? Now we have another case.
Yes, sir.
And this is cause number 23CR1270. And what do we,
Here's this one if you want to just fill it out and then.
we had to start over from the beginning. On it. So good. Machinery's not working right now. It's a good sign. It's good luck in Haiti, but not here.
Haiti.
Call the second case on Mr. Everfield, and this is cause number 23CR1270. Does the defendant waive a formal reading of the indictment and the arraignment in this case?
Yes,
Can
we
we
do.
proceed in summary?
Thank you.
In this particular case, sir, the indictment alleges that on or about April 14th, 2022 in Jefferson County, Texas, you committed a third-degree felony of tampering or fabricating with physical evidence with intent to impair it in a murder investigation. Do you understand what you were charged with?
Yes, sir.
If convicted, you face a term of not more than 10 years or less than 2 years in prison. In addition, a fine may be assessed not to exceed $10,000. Do you understand?
Yes, sir.
An agreement has been reached in this case. You would be pleading guilty, sentenced to 10 years in prison. This one's concurrently.
Yes, Judge.
Will run concurrently with the murder case that you were just sentenced to in cause number 22-39802. Is that your understanding of the plan?
Yes, sir.
If I follow this agreement, you have no right of appeal of your case. Do you understand?
Yes, sir.
How do you plead to this charge, sir? Guilty or not guilty?
Yes,
So you're pleading guilty voluntarily, and because you are guilty,
yes, sir.
I show you what's marked as State's Exhibit 1 as well on this case. Did you sign that? Understand it? Discuss it with your attorney? Are the contents all true and correct?
Yes, sir.
State's Exhibit 1 tendered into evidence.
No objection.
Without objection, it's admitted. Among other things, again, this state you are mentally competent to enter your guilty plea. It's freely and voluntarily made. You know what you've been charged with. The indictment's been read to you. You've read it. You are guilty of the crime charged and any lesser included offenses. You are giving up your rights to a jury trial and the rights to the appearance, confrontation, cross-examination of witnesses. Totally satisfied with the representation of your attorney on this case. All true at state, so help you God. State's Exhibit 1 was made a part of the record for all purpose. Pre-sentence report waived. If nothing further, I'm going to follow this agreement and find Mr. Everfield in this third-degree felony of tampering or fabricating with physical evidence. I am going to find you are mentally competent to do this. You will have an understanding of what you're charged with. You understand fully the consequences of pleading guilty. There's sufficient evidence supporting your guilty plea from State's Exhibit 1 admitted here to find you guilty beyond a reasonable doubt, and I so find you guilty of this third-degree felony. I am following this agreement. You are hereby sentenced to confinement in the Institutional Division of the Texas Department of Criminal Justice to serve a term of 10 years, and this sentence shall run concurrently with the sentence in the murder case previously assessed today in cause number 22-39802. Do you understand what has happened, sir?
Yes, sir.
Anything else?
Nothing much.
That is all. Thank you.
Thank you.
Good. That's it off the trial docket, correct? Yes?
Yes,
So far, Judge, Mr. Burbank did let me know that Cedric Fontenot was going to be a plea.
wait, no, Mr. Burbank, huh?
Okay, Langston,
I'm ready.
Andrew Diaz,
That's a plea. I sent it to you already.
where's he? In the
He's in the
back.
back.
Andrew Diaz, please. Andrew Diaz.
I sent it.
You got it. I got it. We all have it.
We good, we good.
Do you need to fingerprint?
Yes, sir. He's not having a fingerprint. Uh-oh.
Thank you.
Mr. Diaz, please raise your right hand to the forefront and tell the truth and truth and nothing but the truth, so help you God. Just repeat after that. Sound correct? There. Repeat it up one more time. Same one. Place right here. Okay, okay, that's-
We now call cause number 25, CR 642, the state of Texas versus Andrew Diaz. That's you.
Yes, sir.
Present with Mr. Adams, your attorney and the state's attorney. And does the defendant waive a formal reading of the indictment and arraignment? In this case, can we proceed in summary?
Yes, sir.
In summary, sir, this indictment alleges that on or about April 19th of this year, 2025, in Jefferson County, Texas, you committed the second-degree felony of aggravated assault with a deadly weapon. You understand what you are charged with here?
Yes, Your Honor.
This is a second-degree felony, which means if convicted, you face a term of not more than 20 years or less than 2 years in prison. In addition, a fine may be assessed not to exceed $10,000. Do you understand?
Yes, sir.
The agreement's been reached where you will be pleading guilty and placed on deferred or unadjudicated probation for up to 10 years. And is there any restitution here? No. There will be other terms and conditions of probation, which are normal and customary for this type of offense. Is that your understanding of the plan in this case?
Yes.
If I follow this, you have no right of appeal of your case. Do you understand?
Yes, Your
How
Honor.
do you plead to this charge? Guilty or not guilty?
Guilty.
So you're pleading guilty voluntarily. And because you are guilty,
Yes, Your
I'm
Honor.
going to show you here what's marked as State's Exhibit 1. Did you sign that document voluntarily? Understand it? Discuss it with your attorney? Are the contents all true and correct?
Yes, Your Honor.
State's Exhibit 1 tendered into evidence.
No objection.
Without objection admitted. Among other things, this states you are mentally competent to enter your guilty plea. It's freely and voluntarily made. You understand
Yes,
what you're charged with? The indictment's been read to you. Are you ready? Do you understand it fully? You are guilty of the crime charged in any lesser included offenses, and you are giving up your rights to a jury trial and the rights to the appearance, confrontation, cross-examination of witnesses. Totally satisfied with the representation provided by your lawyer here. All true.
Yes, sir.
State's Exhibit 1 is made a part of the record for all purposes. In this case, pre-sentence report is waived.
Yes, sir.
I will follow this agreement and find, Mr. Diaz, you are pleading guilty today voluntarily. You're mentally competent to do so. You understand and appreciate the consequences of pleading guilty.
Yes, Your Honor.
There's sufficient evidence supporting your guilty plea to find you guilty beyond a reasonable doubt in this case. However, the court is going to defer any finding of guilt and place you on deferred or unadjudicated probation for 10 years. You do well, it can be shortened to 1/3 of it. There will be terms and conditions of probation, including anger management, which helps you make decisions under crucial decision-making situations. And that will help you. Also, the court, even though you have not been found guilty, so long as you follow these terms and conditions of probation, court finds there is sufficient evidence to support an affirmative finding that a deadly weapon, namely a firearm, was used in the commission of this offense. It will not have any practical application unless you fail. Then your probation can be revoked. You can be then found guilty, sentenced up to 20 years in prison, and that prison sentence would have to be served at least 50% because of the affirmative finding of a deadly weapon. So a lot riding on you doing well. So are you going to do well?
Yes, sir.
Okay, it's up to you. Anything else? And that is all. Please just talk to the probation officer and
Judge, there's an issue we need to deal with off the trial docket on Jim Bailey. There's some subpoenas that were, some motion to quash were filed that I think we need to deal with an issue that's come up many times if we could, please, sir. So we got Mr. Stelly here's, filed the, I think the objections to him.
Where that's going to.
There's also, wasn't there another one?
Yeah,
Howard Price?
Howard Price, yeah,
No?
yeah, deal with them both.
Okay.
Oh. Did you get my response? I emailed it.
Wait,
You won't, I have
that's
to
a
take.
question. I don't know.
I emailed everybody. Mrs. Stelly was a part of the email.
That was attached to files.
You want to take a time, look at my response before we, so I have some other matters.
This is just an issue that's come up and I think we need to deal with it so we can figure out what to do from here on out. I think that
Okay, it's not set in the queue for trial today, correct?
No, well, no.
it's on the trial docket, but it's,
No, I didn't name it on trial,
No,
though, right?
no,
No,
sir.
I named others.
no, so that's why, but this is going to come up again and again, and we kind of need to have an answer.
Okay, we're gonna stop everything we're doing and work on this then, right? That's what everybody wants.
Yes, sir.
Well,
Look at this, sir.
Did you see my
No.
response? Yeah, I went to read my response before.
You back it down.
Yeah, so we can do the other stuff.
This is Bailey, right?
Because you had a chance to read my response.
Yeah, I hadn't read it,
Right. Judge, I got another.
but I can. I'm a speed reader. Oh, we have two cases I'm looking at.
Yes, sir.
Yes,
Yes, the same issue.
Price?
Yes, sir.
Yes, sir. And what I basically did, what I basically did was prepare and submitted my response in a similar case next door. And I provided that to Mr. Stalway. He already has it in the court as well, because the issues are exactly the same. And it says defendant's response in opposition to motion to quash subpoenas.
Okay, these are
These are subpoenas to law enforcement agencies asking them for
understand.
things that we're required to give them in discovery.
But that's why I wanted you to read the response, because in my response, I cite several statutes and cases.
Wait, it looks like they're word for word the same, right?
Yes, sir.
Okay.
One paragraph different, Your Honor, but yes, for the most part the same.
Okay, tell me, before these objections were filed, what was the status of the case and what precipitated it?
Well, both of them were set on trial, right?
Yeah. I know that.
The underlying.
You filed, you
He
sent,
filed a motion. I filed my.
stand by. Let's go in time. Cases are filed, they're indicted, then we're getting ready for trial, right?
Yes, sir.
And then you file subpoenas. You send out subpoenas for witnesses, correct?
Correct. Documents.
Documents.
For documents to the chief of police.
Correct.
Port Arthur. Okay. Then that triggers a response
Correct.
that Mr. Stelly is representing, I guess, the city of Port Arthur.
Yes, sir.
On.
Correct.
And what was the reason for your subpoena for the chief of police?
Well, it's for the documents, not for him to testify personally. In particular.
What documents are you
Okay.
attempting to
Well,
get before the fact finder?
one is any and all police reports relating to Linda Jones, who was the complaining not the complaining witness, but the mother of the complaining witness in this case, and any and all police reports related to my client, Howard Bloom Price. Now, the state's position is that you have to get that information solely by request under 3914 through the district attorney's office. What I cited in my brief, Judge, and I actually look at it and I highlighted the key points, is there's nothing in the law that states that, nothing, zero. Matter of fact, if you read 3914, the language of 3914 is specifically the state shall produce. It does not say district attorney. And courts, and I've cited the cases, have defined state as law enforcement, district attorney's office, big umbrella. That is the state. And also, I would like to bring to the court's attention that 3914 is not something that's mandatory by the to be invoked by the defense. So if I don't invoke 3914 at all, if I never send a letter requesting discovery at all, I am still allowed to subpoena documents from law enforcement. There's nothing in, if 3914 is triggered by the defense making a request. And specifically, Judge, what I did was I highlighted for you, just so you don't have to read everything. If you just look at what I highlighted.
What's this? Oh,
well, yeah, that's the response. Now that's the response in another case, but the issues is the same. So I just included in this, and I sent that email to you. So the long and the short of it is that when you look at their objection, in their objection, I don't see any case. And specifically when they refer to 3914 itself does not say that discovery in criminal proceedings shall go through the district attorney's office. There's nothing in 3914. I asked them to bring out 3914. I have 3914. They can't read that to you. It doesn't exist in the statute. The statute does not say that at all. Also, specifically, 3914 does not. There is nothing in 3914 that precludes you from sending a subpoena to law enforcement for records. And these particular records are relevant in my particular case. Also, there's been many times where, for example, the state will, when the PD puts together a case, it's not necessarily the PD is even giving the state everything that's in their files. So particularly, my position is the argument that they're making is not supported by the statute that they say, and you can plainly read the statute itself. It says state, and it's not even triggered unless the defense even sends a letter. So at the end of the day, Judge, my position is very simple. What they're requesting is not supported by case law, because if you look at their motion, they cite no case law, none, zero. And then the statute that they cite, it does not say what they propose. So they can't win on a statute that doesn't even support their position. So I would ask that the subpoena objections that they made be denied, and that we prevail on the principle of that what they cite is not even in the law. And I got the law itself to read. I included that in my response.
what are you trying to seek from the Port Arthur Police Department?
So, for example, in there, and Mr. Laird, I mean, he's representing the state.
What are you trying to?
I'll give you a specifically.
Yeah.
So
Just don't tell me.
No.
The Constitution was written. Just tell me what did it say.
So specifically, like in the Howard Glenn Price, Linda Jones is the mother of the child, right? So I requested any and all documents, police reports that is not in this is something that's not in the discovery portal. So relating specifically to her, because I'm entitled to impeach their witnesses. And she is going to be the main witness besides the child. As it relates to my client, they can offer anything they want to offer as far as punishment of my client. They can offer any relevant conduct as far as punishment when he takes the stand. That is not in their discovery portal at all. And I asked that specifically, any and all reports, investigative reports, call service relating to Howard Price. That's my client. I'm entitled to that for my client. Mm-hmm. And any other information about this particular case that they haven't produced. My point to you, Judge, is, and like I said, I've read 3914 several times.
You said that several times.
Right, and you're right, I apologize. It does not, the statute does not say what it's not in there. You can read it, it's not in there. So again, with that being the case, the long and short of it, they subpoena my client's medical records. They don't come to Langston and say, well, hey, can I get you the client's medical records through you? If they subpoena his school records, my client's school records, they don't say, well, hey, they go directly and get them. I can do the same. And matter of fact, since they mentioned 3914, I'll give you the best case example, Judge.
Where does this end?
Well, here's where the end right here.
Just get the
here's where the end right now. Here's where the end right now.
Okay.
Prior to indictment, my client would be entitled to an examining trial prior to indictment. All right. It's my understanding, Mr. Laird can tell me, the district attorney's office does not give you discovery prior to indictment. If I have an examining trial, I can subpoena whatever records I want to from the police department. So
no.
at the examining trial.
No, you can't.
I'm sorry.
There's always built in a relevance.
Well, yes, you're right.
Oh, relevance.
You're correct.
It's the spirit of all law.
You're
We
correct.
just don't ask for, we want every piece of paper on the planet.
You're right.
And we'll wait as long as it takes. It has to be relevant and reliable.
Correct.
Relevant and reliable, the two R's.
I misspoke.
And, no, yeah, but I know what your point, what you're trying to get is as much information as you can,
Correct.
which is what a vigorous defense attorney has an obligation to be that way.
And Judge, I think.
But what is the relevance of this matter that you're asking for? What is it relevant to a fact issue in this case?
Well, they're not going to put on their case without Linda Jones as being the mother. So Linda Jones' police reports, investigative data is relevant to the issue of one, her credibility. Did she make any of these claims against my client in the past? Has she made false claims before in the past? Any issues regarding that would be relevant to this case. My client's own prior cases, which could be used in punishment, as well as to critique him, as well as any and all documents for this particular case that have not been produced, would be relevant to his defense, specifically he did not sexually assault this child. And Judge, in terms of that, at the very least, and I think the court has done this in the past with CPS records, is that I would ask the court to look at the records that they have in county and then give them to me. Yeah, you find records, look at them in county.
There's a motion for that you file. You got to, Judge, he's just trying to surpass the discovery that's required by 3914 and also by all the rules of evidence that the state is required to give him. If he would request it from us, we could give him what he wants, but we've got to do a central location where he's not causing all these agencies to try to figure out whether they've
Yeah, I'm not going to open the door.
But
for that.
no,
They're willing to work with you.
Yeah.
Do it like we've done it for 18 and a half years here, but here, we don't have a problem with it. But you just can't get a carte blanche request of data. It has to be relevant, reliable, and because data in criminal law, in criminal matters, is vast.
Yes, sir.
You've got to pinpoint it so that we're not chasing our tail and spending a lot of valuable time unwisely.
And I think
And also here, also, you're wrong when you say I get to know everything about somebody. No. When you have requirements under the law that the state has to provide for discovery, which is mandated, and exculpatory information. Then when they put their witness on the stand, then you may end up opening a door of information based upon their testimony. But you can't open the door until it's unlocked.
And the same arguments that I made apply to both cases, Judge. It's not, we're trying to handle both at one time.
It's right now, I find it premature. And you're going to be required to give all exculpatory information and the information ahead of time under what 3914 is always.
You never talk to
Also, y'all got to communicate before you get to me on this, and folks don't, because I'm going to be flexible. It's in the Constitution. The Bill of Rights have all the rights. I'm sensitive about it. I wrote a big article on it. I'm very proud of that.
Well, I hope you enjoy reading my brief.
Yeah, it's good. It's good. But I think it's premature. You may want to throw that out. You reassert it. It's in there. You can reassert it. But right now, let's work one step at a time and see. Yeah, I just don't want.
Work through the show.
Yeah. Yeah. I don't want them to. Yeah. You're asking to. What you want is just information. You don't want to read War and Peace at every page of War and Peace. You want to get
not every page.
what's the subject matter that is relevant to you.
You taking on both those cases? Huh? You doing both? Thank you, Your Honor. No, maybe.
Yes. You're excused. Thank you.
Thank you.
So I'm going to hold these motions in abeyance
Thank you,
and
Judge.
take them up later when it's right. Now I've got
Judge, I got another plea off of the,
Who is it?
that's going to be Mr. Jacquet. I sent that to you
Justin
as well.
Jacquet? Justin Jacquet, please. Here.
I sent that, Judge. You got it. And that's Mr. Jacquet.
In front of that lady, and she'll swear you in, sir. Thank you.
Jacquet, please raise your right hand. You swear or affirm to tell the truth and the truth and nothing but yourself, you shall. Okay. The right thumb print, right thumb. There you go. Right there. And get up one more time. I need the whole thumbprint. Okay, you go stand in front of the judge.
I need this one.
Sure.
Hello. Mr. Adams,
I'll come back. I was just checking my client.
your client needs legal assistance here.
Appreciate you.
25 CR 772 is now called, the state of Texas versus Justin Jacquet. That's you. Present with Mr. Adams, your attorney and the state's attorney. Does the defendant waive a formal reading of the indictment and the arraignment here? Can we proceed in a summary?
Yes, sir.
In summary, Mr. Jacquet, this indictment handed up in June of this year by the grand jury states that on or about April 25th, 2025, in Jefferson County, Texas, you committed the third degree felony of theft of services. Do you understand what you are charged with? This, because the value of the service is $30,000 or more, but less than $150,000. This is a third degree felony if convicted, which means you face a term of not more than 10 years or less than 2 years in prison. In addition, a fine may be assessed not to exceed $10,000. Do you understand what you are facing here? An agreement has been reached where you would be sentenced to 10 years in prison. That would then be suspended. You would be placed on regular probation for up to 10 years. Most importantly, we need the money paid back, the loss, which is $1,257.97. Is that your understanding of the plan? If I follow this agreement, you have no right of appeal of your case. Do you understand? How do you plead to this third degree felony of theft? Guilty or not guilty? I'm sorry.
He said guilty.
Are you pleading guilty voluntarily and because you are guilty? Oh, that one, I found something that worked. Pretty excited, huh? I'm going to show you what's marked as State's Exhibit 1 here. Did you sign that document voluntarily? Understand it? Discuss it with your attorney? Or the contents true and correct?
Yes, sir.
State's Exhibit 1 tendered into evidence without objection?
No objection.
Admitted. Among other things, sir, the state you are mentally competent to enter your guilty plea. It's freely and voluntarily made. You know what you've been charged with. The indictment's been read to you. You've read it. You were guilty of the crime charged in any lesser included offenses. You were giving up your rights to a jury trial and the appearance, confrontation, cross-examination of witnesses, totally satisfied with the representation provided by your lawyer. All of this is true, so help you God.
Yes, sir.
State's Exhibit 1 made a part of the record for all purposes. Pre-sentence report is waived.
Yes, sir.
And are you pleading guilty to this voluntarily, knowingly, intelligently, and upon discussions with your attorney?
Yes.
All right. I'm going to follow this agreement then and find that you are indeed mentally competent to do this. You are mentally competent to plead guilty. You understand and appreciate the consequences of pleading guilty
Yes.
to this third degree felony of theft of services.
Yes.
There's sufficient evidence supporting your guilty plea from State's Exhibit 1 admitted here to find you guilty beyond a reasonable doubt. And I now find you guilty beyond a reasonable doubt of this indicted third-degree felony. I'm following this agreement. You are hereby sentenced to confinement in the institutional division of the Texas Department of Criminal Justice to serve a term of 10 years. That confinement is suspended and you will be placed on regular probation for 10 years.
Thank you, sir.
Now, there will be terms and conditions of probation, which are normal and customary for this type of offense. There will be a theft prevention class that will be required of you and other conditions which help you be the best you can be.
Yes.
Most importantly, there is restitution owed to the complainant in this case, and U-Haul, who is the company he is associated with, as named here. Restitution is owed in the amount of $1,257.90.
Yes.
Now, give me a plan. You're going to get out of jail here,
Yes, sir.
and you know what are you going to do in your life? Fix this, right?
Yes.
Okay, how?
Can I set up a partial payment
Sure.
plan?
Yeah.
Because I'm a
Yes, sir.
disability.
Do you have a plan of getting employment and income? Have you worked something out?
I'm on disability. So
How are you going to pay this?
my disability, the use of my disability.
Are you able to do some kind of sedentary work? Not, not requiring a lot of heavy lifting.
Whatever I have to do.
Okay.
Yes, sir.
Because it doesn't do any good if it takes them 10 years to get this money back. The quicker, because they've lost the money, they lost the use of it. So it's like interest. The cost is going up every day that they don't have their money.
Yes.
Okay. How much, do you have a plan of how much you want to reach monthly on repayments? Not how much you think you can pay when we release you and get you out there in the free world here shortly. Yes.
Yes, sir. I'm a
Yes,
disability.
that's good.
Yes, sir. What's that?
Okay. Why don't we do 150?
Yes, sir.
Okay,
Thank you, sir.
so we don't stretch it. Okay.
Thank you, sir.
You'll be ordered to pay no less than $150. If you're unable to do that, get with your probation officer who you will be meeting shortly.
Yes, sir.
He's the head of the probation office in regards to communication with the courts. Very nice man, but he's not going to be your officer, but he'll go over everything.
Thank you,
But
sir.
if you're unable to, that could result in a revocation. We don't want that. We want you to be satisfied in confident in doing this, but also you've got an obligation to pay these people back as soon as you can.
Yes, sir.
All right. So, and at 150, you're talking about a year,
Yes, sir. Yes, sir.
and then that takes care of it. But anything else?
Nothing, Judge.
All right. Please see the probation officer. Thank you. Good luck.
On Childer one, I think this was the hearing on his evaluation. I think they got him evaluated. I think I got it with you, right? I know he was the guy who I think we all had agreed to meet with William. I think everybody agreed, Judge, that he needed that intervention. That's Childer one. They evaluate him?
Jeremiah,
Yeah, yes, I think you.
where is he? He's in custody?
Yeah.
Mm.
Just the board, you know what I'm saying, too.
All right. What?
I think he's supposed to I know we had filed a motion to get him examined.
Hold on. Let me read it real quick. Motion is before, what's,
He's,
okay, here's your motion, and the issue of consent has been raised in this case with respect to, it's hereby made the disinterested, unless there is competent evidence to support incompetency, as it were,
yes, sir.
defense of insanity. Okay. What do we have in the record that is the underlying facts that support this? It's because the motion is just summary. It's just conclusory, which it doesn't,
I think when we were here last.
I can't remember. What are you talking
When we
about?
was here last?
Yeah,
Can you
correct.
tell-
Any objections by the state for this?
No, you're right.
It's granted. don't have an order. You don't have an order?
I don't think I'll.
Okay, the court is going to grant this motion for examination regarding insanity. Is that all you're asking for?
Yes, sir, that's incompetency, but yes, that's.
Well, I mean, that's a different issue altogether. Competency to stand trial and insanity, which is a raised defense, or apples and oranges.
I say both of him. I mean, y'all see.
All right, then we'll we will order and prepare an order that the court will sign granting this motion for examination regarding insanity. And also, I'm going to expand the examination for competency as well. Based upon the information the court has, we'll put that into an order and get him analyzed. And then we'll all come back and see what the diagnosis is and take up further matters. Okay? But we'll get that into written form, and I will sign the order as soon as possible.
Thank you, Judge.
Yes.
Appreciate you.
I have Cyrus Sandy.
You can bring him out. I gave him his discovery and everything. The offer was 7 years, and he told me no to that.
Okay. Cyrus Sandy.
He's here. Yeah, he's here. And I did convey to him Mr. Henderson.
Okay, I call 25 CR 537, the state of Texas versus Cyrus Sandy. Is that you, sir?
Yes, sir.
Present with Mr. Adams, your attorney, and the state's attorney is present. You are charged with a third-degree felony of fraudulent use. I'm sorry, illegal possession of credit and debit card information. And because it's less than 10 items, and this is credit information and debit card information of others, not you, without their consent. Which is a third-degree felony, which carries with it up to 10 years in prison. You also, it's alleged here you have a prior conviction out of Titus County. Where's Titus County?
Mount Pleasant, Texas.
Mount Pleasant, is that the?
Titus County, Mount Pleasant,
Mount
Texas.
Pleasant. Okay. In the 76th District Court in 2019. And it says illegal possession of a controlled substance conviction. So if you were convicted of the third-degree felony, and if this was proven true at trial, then your punishment is no longer third degree. It turns into a second-degree punishment. And that means you are facing up to 20 years in prison. Do you understand where you are on all of this? All right. Did these 6 different credit and debit cards get back to victims or the rightful owners? Do we know?
I'm not sure.
Y'all got possession of them, don't you, somehow? Or the state?
They took
it.
I got a picture of discovery of other credit.
Fine.
So I'm assuming it's a yes.
So what are we doing on this then today?
This is a picture.
Mm-hmm. Okay.
Picture.
Thank you.
Let me see that.
Here you go.
Let me look at it. Make sure my name's not on any of this. Okay. All right. Where are we? What are we doing? He's not eligible for probation in front of a jury because of the prior conviction. So that's out. You can't get that from a jury. So if you tried this, of course, you're looking at 20 up to 20 years in prison or not. So you can't get regular probation from but you can't. And they don't give deferred or unadjudicated probation. So that's not allowable at a jury trial. So that kind of puts him in a box here. But where are we on trying to dispose of this? Anything?
The offer was 7 years TDCJ.
How much was lost in this transaction? Anything?
I'm not aware of any laws on that.
Not.
It's my.
All right. At the request of the defense, we're going to reset this for 2 weeks and come back and see where we are. Okay, everybody? Thank you.
Thank you, Judge.
Yes. Shoemaker?
Right.
How many do we have here? Three?
Great. One motion to revoke junior cases.
Shoemaker?
That's you, sir?
Yes.
That lady. Thank you.
Help you God. Okay, you got your right hand, friend. Okay. Grab one more time. No, no, no. Go see
Three cases are now called 22-40954 is a motion to revoke probation. That's the older case. And then there are two new cases that are newer cases, 25 CR 858 and 859. Does the defendant waive formal readings of the indictments and the arraignments in these cases? Can we proceed in summary?
Yes, sir.
Everything's going to run concurrently, correct?
Yes, sir.
This is all running together.
Yes, sir.
All right, I'm going to take up the two new cases first in order, 25 CR 858 and 859. In 858, and in these cases, the defendant waives formal readings of the charging instruments. We can proceed in summary. In 25 CR 858, sir, this indictment alleges that on or about March 5th, 2025, in Jefferson County, Texas, you committed the first-degree felony of aggravated sexual assault of a child. Do you understand what you were charged with here, Fred, in this case?
Yes.
If convicted, you face a term of life imprisonment or any term of not more than 99 years or less than 5 years in prison. In addition, a fine may be assessed that cannot exceed $10,000. Do you understand the punishment range in this case?
Yes.
An agreement has been reached where you would be pleading guilty, sentenced to 20 years in prison to run concurrently with other cases. Is that your understanding of the agreement?
Yes.
What is he going to do on the MTRP?
5 years.
Okay, so it will run concurrently with that case as well.
Yes.
It's not written here.
Yes, sir. All there. Okay.
So this would run concurrently with the next case we're going to go into, 859, and the probation case that we're going to be handling in 22-40954. Is all of that true and correct?
Yes.
Yes.
If I follow this agreement, you will have no right of appeal of your case. Do you understand?
Yes, sir.
How do you plead to this charge, sir, of this first-degree felony? Guilty or not guilty?
Guilty.
Are you pleading guilty voluntarily because you are guilty?
Yes.
Show you what's marked as State's Exhibit 1. Did you sign that document voluntarily? Understand it, discuss it with your attorney? Are the contents all true and correct?
Yes, sir.
State's Exhibit 1 is tendered into evidence.
No objection.
Without objection, it's admitted. I'm going to hold this in abeyance for just a minute. I'm going to go into the next case pending, 25 CR 859. And again, does the defendant waive a formal reading of this indictment? Can we proceed in summary?
Yes, sir.
In summary, this indictment alleges that also on or about March 5th, 2025, in Jefferson County, Texas, you committed the second-degree felony of indecency with a child by sexual contact. Do you understand what you are charged with in this case?
Yes, Your Honor.
But this is a second-degree felony, which means if convicted, you face a term of not more than 20 years or less than 2 years in prison. In addition, a fine may be assessed not to exceed $10,000. Do you understand?
Yes.
An agreement's been reached in this case where you would be pleading guilty, also sentenced to 20 years in prison to run concurrently with 25-0858. And let me add this other motion to revoke probation case 22-40954. Is that all true?
Yes.
If I follow this agreement, you have no right of appeal of your case. Do you understand?
Yes.
How do you plead to this case as the previous case, guilty or not guilty?
Guilty.
Are you pleading guilty voluntarily and because you are guilty?
Yes.
On each of these cases, I'm showing you what's marked. These two cases you have pleaded guilty to. I'm showing you what's marked as State's Exhibit 1. Did you sign those documents voluntarily? In each case, understand them, discuss them with your attorney, or the contents all true and correct?
Yes, sir.
State's Exhibit 1 tendered into evidence without objection admitted. Among other things, these states you were mentally competent, to enter your guilty pleas. They are freely and voluntarily made. You know what you've been charged with. The indictments have been read to you. You've read them. You are guilty of the crimes charged in any lesser included offenses. You are giving up your rights to a jury trial and the rights to the appearance, confrontation, cross-examination of witnesses. You were totally satisfied with the representation provided by your lawyer in each case. All true, so help you God. States Exhibit 1 in each case, made a part of the record. Pre-sentence reports are waived here. Yes. On these two cases, I'm going to follow these agreements and find in each of these cases you have pleaded in 25 CR 858, the first degree felony of aggravated sexual assault of a child, and in 25 CR 859, the second degree felony of indecency with a child. You have pleaded guilty voluntarily. You are mentally competent to do so. You understand and appreciate the consequences of pleading guilty. There is sufficient evidence supporting your guilty pleas from States Exhibit 1 admitted in these hearings to find you guilty beyond a reasonable doubt, and I now find you guilty beyond a reasonable doubt of these two felony offenses. I'm following these agreements. You are hereby sentenced to confinement in the institutional division of the Texas Department of Criminal Justice to serve a term of 20 years confinement. In each of these cases, these sentences shall run concurrently. What this means also is that you have additional obligations of filing documentation, and you are going to have to register as a sex offender. And because this aggravated sexual assault involves a child younger than 14 years of age, this is going to be for life.
Yes, sir.
You're going to have to register. And failing to register properly can result in the filing of a felony charge and additional prosecution. So you have an affirmative obligation. The probation officer, when they go over this judgment with you, you're going to be able to do that to explain to him.
What do you need to explain, Joe?
The obligations of registration under the sex offender laws. And do we do that immediately through y'all, or is that done through the jail? Because he's got to do that immediately. And I don't have paperwork here. How do we get that accomplished?
What document specifically is it that we reviewed?
Sir?
What documents?
He's got to register under the sex offender program.
I think,
and
basically, I'm
not telling him how to do that. He just has the obligation. It has to get done. Somebody's got to help him with that. He's not on probation.
I think when he is released, parole, I think
he's got to do it before he's released on parole.
While he's in custody, I don't think he has a duty until he's released.
Correct. I agree with that.
So they'll take care of that once he's paroled.
Okay. Well, the prison authorities will know that he has that obligation, and they know what his convictions are.
And his parole.
They can take care of the necessary within the institution for security based upon those matters.
We do have the notice that's normally signed by defense counsel and the defendant today, Judge. That's on the tablet. That should be done. While you're looking at that, Judge, I've made contact with the family about the plea, but they weren't able to be here before the entry of the plea today. I will confirm if they still want to do an allocution, and we may schedule it later this week, Your Honor.
Did you do that, Mr. Joseph? We may need to bring the defendants back because they have a right under the law to
Mr. Hampton, let me know.
yes, sir, confront the defendant and allocute on what harm has occurred here. But I don't see anything in the tablet that.
I don't think it's been done by the defendant, Judge. I think it needs to be done.
See.
In 22-40954, does the defendant waive a formal reading of this motion to revoke probation here? Can we proceed in summary?
Yes, sir.
And raise your right hand, sir. Do you solemnly swear or affirm any statements you make during this hearing shall be the truth, the whole truth, and nothing but the truth, so help you God?
Yes, sir.
All right, lower your hand. In summary, this motion to revoke probation filed on May 28th of this year, it states that on April 10th, 2023, in this court, you were sentenced to 10 years in prison, and that was probated or suspended for 10 years for the third-degree felony of theft of property. Is all of that true and correct, sir?
Yes.
So you were convicted, sentenced to 10 years in prison, placed on probation for 10 years, and this motion alleges that you have violated that order of probation. I don't see anything, there are no allegations about the two substantive crimes he has pleaded guilty to. All right. Number one violation states that you committed the offense of illegal possession of a controlled substance on or about March 10th, 2025 in Hardin County, which was in violation of condition 1 of your probation order, which states don't commit a crime. Is that true?
Sir.
Are you pleading true to that voluntarily because it is true as it is alleged?
Yes, sir.
Do you understand that a knowing and voluntary plea of true, one or more violations of probation, that is enough to grant a motion to revoke probation by a preponderance of the evidence or greater? Your probation can be revoked and you can be sentenced to no less than 2, no more than 10 years confinement in prison. So for this third-degree felony of theft. Understanding that, do you insist on pleading true today?
Yes.
I find you're pleading true voluntarily. You understand and appreciate the consequences of pleading true. And then finally is allegation 6. This states that you violated your probation by failing to remain in Jefferson County, Texas, and that you were in Hardin County, Texas on or about March 10th, 2025 without permission from the Jefferson County Adult Probation Officer Department or this court in violation of your probation order. Is that true?
Yes.
And are you pleading true to that voluntarily because it is true as it is alleged?
Yes, sir.
And again, the same warning, do you understand that a voluntary and knowingly made plea of truth to one or more violations of probation, that is a grant, the motion to revoke probation? The probation can now be revoked and you can be sentenced no less than 2, no more than 10 years confinement in prison. Do you understand?
Yes.
Knowing that, you insist on pleading true today.
Yes, sir.
I find you are pleading true voluntarily to this allegation as well in this motion to revoke probation, and you understand and appreciate the consequences of pleading guilty. An agreement's been reached where your probation would be revoked and you would be sentenced to 5 years in prison to run concurrently with these other cases. Is that true?
Yes, sir.
Stand by. I had this was since. If I follow this agreement, you have no right of appeal of your case. Do you understand?
Yes.
This states the case will run concurrently. This probation revocation will run concurrently with 22-41105. I don't know what that is.
No, that was a prior motion to revoke state jail felony. That he was previously sentenced to 2 years state jail.
You're asking it also run concurrently with these other two cases, correct?
Yes, sir.
All right.
But that's not in here. Gonna add that. If that right, that's okay with everybody?
Yes, Your Honor. That is a artist's intention.
Okay. I find there is sufficient evidence, again, supporting this motion to grant it by a preponderance of the evidence or greater as allegation 1 and 2 of the motion to revoke probation dated 5/28/25 in this cause number 22-40954. Those allegations are found true. Your probation is hereby revoked. You are hereby sentenced in accordance with this agreement to confinement in the institutional division of the Texas Department of Criminal Justice to serve a term of 5 years in prison. And this sentence, in this case, shall also run concurrently with the sentences in cause numbers 25 CR 858 and 859 of 20 years confinement in prison that have been set earlier to the sentencing of this court in accordance with the plea agreements in those other two cases. Anything else to add?
No, sir.
That is all.
Here, Steve.
Thank you.
Thank you, sir.
Thank you. The court has received from the defense sex offender registration admonishments, documents signed by the defendant in these two cases, and which state that the defendant had been admonished by his attorney, Mr. Dusler, that he has a reportable conviction, which requires sex offender registration under Chapter 62 of the Texas Code Criminal Procedure. And if he moves to another state and requiring similar reporting requirements for sex offenders, he must register in that state. Failing to do these obligations can result in him being charged with additional criminal offenses. He signed these documents as long as this, as well as Mr. Dusler. Anything else to add, Mr. Dusler, on behalf of all of this? Thank you.
Jeff, Steve Thomas, please.
Steve Thomas?
Yes.
Stephen Thomas?
Steve Thomas, please.
Please, thank you. Certainly not the Steve Thomas we know.
No, I don't think so.
File? You've got all of them.
Yes. Sorry.
You hijacked all the files from early. One case here.
That's our case.
Please right hand, please. Okay. Yeah, you swear or affirm to go through the whole truth and nothing but the truth, so help you God?
Yes, sir.
That's what that is. That's what that is.
Yes.
I've had to serve. And just talking about
We now call the case of State of Texas versus Steve Thomas, also known as Stephen Thomas. That's you, sir. Present with your attorney, Mr. Dusler, and the state's attorney, does the defendant waive a formal reading of the indictment and the arraignment here in 25 CR 473? Can we proceed in summary?
Yes, sir.
In summary, sir, this indictment alleges that on or about February 24th, 2025 in Jefferson County, Texas, you committed the second-degree felony of failing to comply with sex offender registration requirements, which require you to register in a regular fashion for life based upon a conviction of aggravated sexual assault. Do you understand what you were charged with here?
Yes, yes.
This is a second degree felony, which means if convicted, you face a term of not more than 20 years in prison or less than 2 years confinement in prison, and a fine up to $10,000 can be assessed. Do you understand the punishment range applicable here?
Yes, sir.
An agreement's been reached where you would be pleading guilty, sentenced to 10 years in prison. Is that your understanding of the agreement?
Yes, sir.
If I follow this, you have no right of appeal. Do you understand?
Yes, sir.
How do you plead to this charge, sir? Guilty or not guilty?
Yes, sir.
Are you pleading guilty voluntarily and because you are guilty?
Yes, sir.
I'll show you what's marked as State's Exhibit 1 there.
Yes, sir.
Did you sign that document voluntarily, understand it, discuss it with your attorney, or the contents all true and correct?
Yes, sir.
State's Exhibit 1 is tendered into evidence without objection. I'm sorry,
No,
it's admitted. This states, Mr. Thomas, that you are mentally competent to enter your guilty plea. It's freely and voluntarily made. You know what you've been charged with. The indictment's been read to you. You've read it. You were guilty of the crime charged in any lesser included offenses. You were giving up your rights to a jury trial and the rights to the appearance, confrontation, cross-examination of witnesses. Totally satisfied with the representation provided by your lawyer. All true, so help you God.
Yes, sir.
State's Exhibit 1. Made a part of the record for all purposes. I'm going to follow this agreement. Pre-sentence report is waived here. If nothing further, Mr. Thomas, I'm going to find you will pleaded guilty today voluntarily. You're mentally competent to do so. You understand and appreciate the consequences of pleading guilty. And you are guilty of this offense, correct?
Okay.
There is sufficient evidence supporting your guilty plea from State's Exhibit 1 admitted here to find you guilty beyond a reasonable doubt. And I now find you guilty beyond a reasonable doubt of this second degree felony of failing to comply with sex offender duties of registration. And I'm following this agreement. As I find you guilty beyond a reasonable doubt, you are hereby sentenced in accordance with this agreement to confinement in the institutional division of the Texas Department of Criminal Justice to serve a term of 10 years. You will be given credit for all time. Of course, you have served in conjunction with this charge. Do you understand what has happened today? Anything else?
No.
Good. I already got him right here. Figure this out. I already got, I already I'm doing 10 right now. Things we run together. You don't like
Unless I send it you consecutively, by law, they run together.
Okay.
And there wasn't an agreement that it runs on top of each other. So it will run concurrently by law.
Thank you.
Yes, sir. Heather Lane,
She's a plea judge.
she's a plea. Heather Lane. Thanks. Never give me any cash. It's always a case. This case file. That's all you have. Nope. There's no cash money over there.
I don't have any cash money.
That makes two of us.
I promise you, I'm trying to raise 2 children.
Yours or somebody else's?
Well,
Oh.
yes, yes.
Don't you have some pets in there too?
2 cats.
Judge, while we're waiting to that plea, on the next page, there's a Michael Cup that the attorney needs to set on the trial docket. He's got to be in another county. We're just trying to get him
Yes,
out of here if we can.
Doing it fast as I can.
Yes, sir, I know.
Trying to get here.
Not complaining, just asking if we can, because he's got a slow drive to go.
You know what? What?
It's on the last pages of regular document on the trial.
Raise your right hand. You swear or affirm to tell the truth and the truth and nothing but the truth, so help you.
Yes, sir.
Please, can you have your right hand, Fred?
Okay. Give me Michael Cups file real quickly. Let me look at it. Thank you.
Just let him know.
That's just the look of the draw. It doesn't come out at the top of the list. We're working as fast.
He's got some charges in another state that we're all trying to figure out. So, and I've got to talk to the victim in this case.
Okay, so we've got the defendant in 25 CR 512. That's who you represent?
Yes, sir.
And you're going to be Mr. Newman?
Yes, sir.
Right? Okay. This alleges third degree felony of promotion prostitution. And is he an habitual felon?
He is, Your Honor.
Okay, there's 3 priors. So
Yes.
generally, I bring them out on these. Bring him out real quickly. If you don't mind, Michael Cupp, CUPP. We're gonna kind of, if you would just step aside just for a second, ma'am, and we're gonna put you kind of in a rotation here, and we'll bring you. Just have a seat there in the jury box next to your lawyer. Thank you.
Taking me out of orbit, Your Honor.
Sure.
Gonna be in Brazos. I didn't realize it was that far of a drive from here. It's only an hour.
In Brazos County,
Two ways.
they're certainly a lot less friendly than we are.
That's where I grew up.
So this should be
So
good.
that's why you're hanging around Jefferson County.
And I'm hanging around Jefferson County because of him.
Oh, you have an obligation here. Come on up, please. Mr. Cup, that you come on up. Mr. Cup. Right up.
Don't be shy.
I recognize you because this is very unusual. The complaint has your big picture in the middle of the complaint. I've never seen that before. There it is, right there. So I recognize you. You were here with Mr. Newman, your attorney, and as you probably know intimately, you are charged in this indictment handed up on May of 2025 here in Jefferson County, Texas, with the 3rd-degree felony of promotion of prostitution. Do you understand what you're charged with?
Yes.
Carries with it up to 10 years in prison. You also have in this indictment, it is alleged a prior conviction in 1995 out of Harris County for burglary of a habitation, a 1st-degree felony. And in 1997, another conviction out of Harris County for the 3rd-degree felony of theft. And that 3rd-degree felony of theft, it is alleged, occurred after you were finally convicted of the burglary of habitation in 95. And then finally, it is alleged that after all of those convictions were finalized, it is alleged that you committed the felony of engaging in organized criminal activity, a 1st-degree felony, and were convicted of that in 2011 out of the 179th District Court of Harris County, Texas, which makes you what we call an habitual offender twice over. And you are looking at, if convicted here, no less than 25 years in prison up to life imprisonment. Most serious case, obviously, but you've got to navigate through with your attorney's help. What are we going to do today?
I would like to put it on the trial docket with the court commission.
You got it. And so we're putting on the trial docket. No deals then, right? Okay. All right. Then that's get this as soon as possible.
Yes, sir.
Okay.
Thank you. I appreciate it.
And you understand, I don't know if you're going to be serving any other sentences. If you're convicted, as you probably know, that the sentence, if convicted and sentenced, it will run consecutively to others. It can run consecutively to all other cases that you may be punished for.
Yes.
Okay, just so you know where you stand on all of this. Okay. Anything else?
No.
Okay, thank you. We'll set it for trial as soon as we get there. Thank you.
Reset,
Open it to you now. Where is he? Come on.
with the potential plea, Judge.
We got to put something on the record.
Yes, sir.
Who is it? Who is it?
It's Uncle Jimmy.
Jeremy.
No, me to bring you in, I need to ask you a question.
Hold on, stand. 24 CR 2167 is called Jeremy. Is it Ojimini?
Yes.
Pronouncing that right? Good. And what is that?
Nigerian.
Nigerian. Oh, that's a beautiful country.
Yes.
Anyway, you are probably know you're charged with a third-degree felony of assault on a public servant, which can carry with it up to 10 years in prison. You understand what you're facing? You have to speak out so she can take it down. Yeah, do you understand what you're facing?
I understand.
Okay. Mr. Samuel is here representing you, and he says that there's a situation that needs to be dealt with here before we can move forward in this case. I think there's a plan to get you some medical assistance here in dealing with this case and what happens next. As you have earlier been found in August to be competent to stand trial, which means you're free to come to trial. I think there are some other issues that your lawyer is looking at to make sure that he's trying to get you as healthy as possible. So we're going to have to reset for a few weeks. How much time?
2 weeks.
Is 3 going to be?
That's fine.
All right. Look, why don't we do 3 weeks, which should give it enough time to work these issues out. Make sure that you follow his advice. He's a smart guy and he knows how to help his clients. And we want you to be healthy, physically and mentally here to be able to move forward for an informed disposition in this case. Okay. All right. So he's here kind of like you're lost in the woods. He's tracked you down and he's going to bring you out of the woods safely. Okay. All right. Anything else?
Yes.
Okay. That is all. Thank you. You are free and we'll just get a resetting for you, Otwin. Okay.
Yes, sir.
Next is Reagan. It's who? Is it?
Heather Lane.
Heather Lane. I'll be on. Oh, there it is.
Page 3.
Page 3. 25 CR 655 is called the State of Texas versus Heather Lane. That's you. With Ms. Nanavy, your attorney, and the state's attorney. Does the defendant waive a formal reading of the indictment and the arraignment here? Can we proceed in summary?
Yes.
In summary, this indictment alleges that on or about April 11th, 2025 in Jefferson County, Texas, you committed the state jail felony of unauthorized use of a motor vehicle. Do you understand what you were charged with here in the indictment?
Yes, sir.
This is a state jail felony, which means if convicted, you face no less than 180 days, up to 2 years in the state jail, and a fine up to $10,000 can be assessed. Do you understand what you're charged with?
Yes.
And we're getting all these indictments out of this this last grand jury, and you can see the foreperson here has a real large signature. Yeah, so that the defendants understand and appreciate the seriousness of these charges. All right, a plan has been reached, correct?
Yes, Judge.
So
Plan has been reached here where you would be pleading guilty, sentenced to 1 year in the state jail with all time credited that you've served toward that sentence. Is that your understanding of the agreement?
Yes, sir.
If I follow this agreement, you have no right of appeal of your case. Do you understand?
Yes, sir.
There wasn't any restitution on this, was there? Because it's unauthorized use of a motor vehicle. A lot of times people take the car and then wreck it.
The car was recovered.
Okay. And again, how do you plead to this? Guilty or not guilty?
Guilty, Your Honor.
You're pleading guilty voluntarily and because you are good. Show you what's marked as State's Exhibit 1. Did you sign that document? Discuss it with your attorney. Are the contents all true and correct?
Yes, sir.
State's Exhibit 1 tendered
No
into
objections.
evidence. Without objection, it's submitted. Among other things, the states you are mentally competent to enter your guilty plea. It's freely and voluntarily made. You know what you've been charged with. The indictment's been read to you. You've read it. You are guilty of the crime charged. And any lesser included offenses, you are giving up your rights to a jury trial and the rights to the appearance, confrontation, and cross-examination of witnesses, totally satisfied with the representation provided by your lawyer. All true, so help you God. State's Exhibit 1 made it part of the record for all purposes. Pre-sentence report is waived here.
Yes, Judge.
I will follow this agreement. I'm going to find that you are indeed mentally competent to enter your guilty plea. You have pleaded guilty voluntarily, knowingly, and intelligently. Is that true?
Yes, sir.
To this state jail felony, there's sufficient evidence supporting your guilty plea from State's Exhibit 1 admitted here to find you guilty beyond a reasonable doubt. And I so find you guilty beyond a reasonable doubt of the state jail felony. Unauthorized use of a motor vehicle. And following this agreement, you are hereby sentenced to confinement in the state jail for a term of 1 year. And again, will be given credit for all time you have served in accordance with this case. Understand what has happened to that? Good luck. All right.
Thank you, Judge.
Thank you, Mike.
I have a John David Simeon Watkins.
He is pleased, well, Judge.
John David Simeon Watkins.
Or, or. The Watkins part. Should be.
Yeah.
It's Lisa's cousin.
Come forward, sir. And you need to see him over here to get a fingerprint. Thank you.
Raise your right hand, please. You swear or affirm tell the truth and the truth, nothing but the truth, nothing but the truth. Your right hand.
Right. You bet.
Okay. One more time. Let's. Okay.
25 CR 51 is called the State of Texas versus John David Simeon Watkins. That is you, sir. With Ms. Manaldi, your attorney and the state's attorney does. The defendant waive a formal reading of this indictment and the arraignment here. In this case, can we proceed in summary?
Yes, Judge.
In summary, sir, this indictment alleges that on or about October 25th, 2024, in County, Texas, you committed a felony of aggravated assault with a deadly weapon, namely an automobile. And a fence, which is interesting that it was used as a deadly weapon, the fence.
The domino effect.
That's the way it's alleged. A second degree felony. Do you understand what you're charged with here?
Yes, sir.
You're facing a second degree felony, which means you face a term of not more than 20 years or less than 2 years in prison, in addition to finding it itself out to exceed the quality of life. Really not science. Prison, 10 years in length, rather, and you do well, it's shortened to 1/3, as much as 1/3. And restitution is owed, and that is still to be determined.
And Judge, there may or may not be any. It's been a little while since I talked to the complainant. I'm going to call him back and see if there was any action.
What do we do today? Place him on probation, and everybody agree that restitution may indeed be assessed?
Yes,
and
Yes, Judge.
I need, though, to assess that.
Yes,
So
sir.
at the
With the
time,
understanding that an amendment to those probation conditions might come with a proper restitution amount.
you understand where we are on that, sir. You could be paying restitution back, which is where you fix things on when it's loss of value of property. And the quicker you fix it, the quicker you get rewarded. That's all I want is put this back, put the victim back to hold. I don't know what that is. But is that your understanding of the plan? If I follow this agreement, you have no right of appeal of your case. Do you understand?
Yes, sir.
How do you plead to this indictment? Guilty or not guilty? Are you pleading guilty voluntarily? That is on your own free will and because you are guilty. Yes?
Yes.
I show you what's marked as State's Exhibit 1. Did you sign that document voluntarily, understand it, discuss it with your attorney, or the contents all true and correct?
Yes, sir.
State's Exhibit 1 tendered into evidence and without objection it's admitted. Among other things, this states you are mentally competent to enter your guilty plea. It is freely and voluntarily made. You know what you've been charged with. The indictment's been read to you. You've read it. You are guilty of the crime charged with any included officer. You were giving up your rights to a jury trial, rights to the appearance, confrontation, cross-examination of witnesses. You were totally satisfied with the representation provided by your lawyer.
Yes, sir.
All of this is true, so help you God.
Yes, sir.
State's Exhibit 1, made a part of the record for all purposes. Pre-sentence report is waived.
Yes.
I will follow this agreement,
Thank you.
if nothing further, and find you, Mr. Simeon Watkins, are pleading guilty voluntarily to this second-degree felony of aggravated assault with a deadly weapon, namely an automobile, and offense according to the indictment. You understand and appreciate the consequences of pleading guilty. There's sufficient evidence supporting your guilty plea from State's Exhibit 1 admitted here to find you guilty beyond a reasonable doubt.
Yes, sir.
But I am not going to find you guilty. I'm going to place you on deferred or unadjudicated probation so long as you follow terms and conditions of probation, which are normal and customary for this type of offense. Probation officer is going to go over with these with you here in a moment. Make sure you follow these. If you fail, your probation can be revoked. You can then be found guilty and sentenced up to 20 years in prison, the full range. We don't want that. Also, restitution is going to be owed. We're going to figure out what that is. Everybody's agreed it is. You are liable for it. We're going to figure it out, and you probably not going to be able to write a check for it. I don't know.
I don't know if there were any injuries. It was it may be to the fence a little bit, or the and I'll see if he did actually have any hospital. I don't think he did. I think it was just maybe hit his knee a little bit, but I will just to make sure. Yes, sir.
Well, property damage.
There may that to the fence. I'm gonna see about the fence.
It
was
I don't think so. I
No.
don't think he was accepted.
Okay, it doesn't sound serious. The point, not to make it light.
It wasn't serious.
Okay, you would know. Okay, we're not there. You know,
Right.
that we're not going to tell you anything you don't already know. But whatever it is,
Yeah, I'm
the court's going to order you to pay back if you feel, oh, wait a second, that $1 million is a little much here. I'll resolve it.
Thank you.
Okay, if there's a dispute. But restitution is going to be ordered in an amount all parties have agreed to be determined later if there is an issue. And that will be a part of the requirement for probation to be paid back as soon as possible.
Yes, sir.
And if you need some time, then we can give you some time on a zero interest payment plan.
Okay.
But the quicker the people get paid back and put whole again, the quicker your probation ends.
Really?
Yeah, boy.
Thank you.
I can finish it and suspend it and complete probation in 1/3 of the time. So 10 years here, 3 1/3 years.
Okay.
So,
Thank you.
if as long as you do your part.
I will.
Okay. So see the probation officer, and hopefully good things will come about here for everybody.
Thank you.
Thank you.
Thank you. Thank you.
You're welcome.
This has been all nice.
Sorry. He's trying to find it where he is on this. I can't.
It's my mate.
I have it. Yeah, Christopher. Okay, I have, no, it's Simeon one.
Simeon.
It's John Davis.
John Davis.
Those are Miss Manala's, other three.
Page 3, Judge.
I lost page 2. Oh, we completed page 2.
Yes, page 2 is complete. I start on page 3.
Oh,
I have Marcus Avita.
Yes, I have spoken with the judge. I'm still reviewing the offer with him. He
This
also
time?
4 weeks.
Okay.
Please.
4 weeks. You got it. The request for additional time on Marcus Avila, it's 25 CR 277, reset 4 weeks at request of defense. In 25 CR 225, Leon Davis.
Judge, I've spoken with ADA Gasper about that case. I think I might be missing a body cam relevant to one of the police officers that were there that day. She's gonna look into it for me. If we could have 4 weeks to try to resolve that issue.
That's correct, Judge. There is an offer on the table.
Yes.
Said 4 weeks on that one. And Rex Powell, also Miss Gasper.
He is a motion to revoke probation.
Yeah.
He is going to voluntarily plead true to one of the allegations.
He just looks like
To number 3, Judge. So,
non-substantive type.
yes,
It's
they
not
are.
a crime.
And he has a very high level of restitution if he has to pay back. I do have a interested party here on behalf of him that has a job set up for him if he was to be reinstated so that he can make payments.
Does he want to be reinstated?
He does.
Oh, okay. That's the important part.
Yes, and he is adamant that he will be successful on.
Okay, where are we on paying it back?
He has not paid anything. He has not reported. He has not shown up to anything, done any of the classes or
No.
paid anything.
That we're running into
It was this.
Has he been in jail?
since.
Let's see what Lisa said. I mean, he just walked off the job. You get punished.
So the issue that we ran into also, Judge, is you had ordered some upfront time for him to do, but he had trustee calculations. So they calculated his time. They gave him trustee credit for his days. So they have let him out. He reported to probation, but then they told him that he was not supposed to be let out, that he had those 35 days, day for day to do. And he went back and reported himself back to the jail to complete those 35 days. And then he was released January 22nd of 2025 of this year.
And from the time that he was released, Judge, he didn't do anything on
Yes,
probation.
there was no other contact with probation after that. But
So he didn't report again.
he didn't report again.
Oh, okay.
And then this motion was filed in March of 2025.
How long has he been in jail this time?
he was arrested June 26th of this year. So 82 days as of today.
How much time does he have credit for so far? On this case? So we haven't,
He has 173 days.
so we have not, determined what the restitution is yet?
Restitution is $32,500, Judge, and has not made any payments towards that restitution as of yet.
That's correct, Judge.
No. Like, let's get the defendant out here. It's Rex Powell. You have a pre-sentence report from probation and this thing. Come on up, sir.
Yes, sir.
And in 21-3-8-4-5-7, you were Rex Allen Powell Jr., correct?
Yes, sir.
And as you know, you're on probation in this case.
Yes, Your Honor.
For the second degree felony of theft, third degree felony of theft, which carries with it up to 10 years
Yes, Your Honor.
in prison. All right. So we have a loss in this case of over $32,000 to the victim, which is, um, I've never seen an affidavit for an arrest warrant so interestingly worded. This states that you stole $32,500 from the victim by using guile and deceit. Interesting use of verbs that we generally don't use guile, but it shows that the officer in this case took English classes, I'll tell you, through school. But we place you on probation here. I agree to this. And this was in December of last year. So we're headed toward a year, 9 months anyway, into this. And according to the probation office in the state, you hadn't done much anything. And there's a motion to revoke probation that has been filed now that states you failed to report to the probation office since December 10th. I placed you on probation the day before. Who does that? You walk right off the job. We hired you and then you left town. When was he placed in custody? When was he arrested? I'm curious. Anybody? No.
I think Lacey said it was in June. But remember, he had those issues at the beginning of his probation where he was let out and then he had to go back to jail. So he went back and wasn't released from Jefferson County until January 22nd of 2025, which doesn't fix the overall issue. But I just wanted to remind that he did self-report back.
Yeah, the thing is, you know how important all of this was, that we're serious about it, because when we catch you, we throw you in jail every time. So then you leave. When did you leave jail the last time?
January 22nd.
January 22nd. And when was he arrested?
June 26th.
All right, 6 months later. All right. Where were you? You certainly weren't at probation.
Wisconsin. I was doing my community service. I was doing my community service.
What were you doing? What community service were you doing?
I
Your own community service?
Sir, I did 87. Well, actually, I did 115 hours of community service at Henry's place, but then they lost the paperwork, and now Miss Linda Court has the paperwork. I was in the process of getting my driver's license.
How many times did you report to the probation office?
Just the once, and because I went through some mental anguish because of I've never been in this situation. My dad got cancer.
What do you mean you've never been in this situation?
Never been homeless. I've never been. Well, I ain't been in trouble for 20 years, and I apologize. I just want the opportunity to prove that I can't do this. And I was trying to get my new Social Security card,
Hold on.
certificate.
Hold on.
Yes, sir.
You're railing on, and I'm not going to let you look at me and lie.
I'm not. Yes, sir.
Raise your right hand. You solemnly swear or affirm any statements that you make during this hearing will be the truth, the whole truth, and nothing but the truth, subject to prosecution for perjury, so help you God.
So
Lower your hand.
Yes, sir.
You hadn't been in trouble how long?
I think it's about 17 years.
17 years. 2012, you were convicted in, was it Dare County, North Carolina? 6 to 8 months confinement.
That was the last time.
No, wait.
Yes, sir.
Do the math. That's 13 years ago, mister.
I'm sorry.
You're going to look at me and lie?
It was
You
time-
can't do math above 13 years?
I'm just bad with time perception. I'm sorry.
Oh, are you?
Yes, sir.
Yeah, I think you're bad with truth perception.
Yes, sir. I'm sorry.
No. And we've got, let's see, non-support, Dare County in 14, failure to appear in 2012, failure to appear in North Carolina, DWI in North Carolina in 2011. All that's within 20 years. Your earliest crime is 2002 conviction in North Carolina, 2002. And let's see. I've never seen this one. A felony of littering with using, you littered more than 500 pounds of debris and were convicted of that. That was some kind of littering.
It's a vehicle.
And then you get this illegal possession of a controlled substance on the prison or jail premises. Are you kidding me? Who does that? And then convicted for that. All right. Now you have this felony theft. And we put you on probation after all of that mess. And you walk right off the job. You just don't seem to appreciate the seriousness of what goes on in a criminal courtroom. Plus, you're just plain dishonest. You've shown that this is what you do. You deceive. And what was the words in this probable cause that the officer used? Let's see. You're using guile. And deception in this courtroom. Anyway, enough of that. So, there's a motion to revoke probation. What do we plan to do?
Judge, the state has offered pen time in this case. Given the situation and the hefty amount of restitution, we wanted to bring it to your attention before moving forward in any way.
Okay. What we're going to do is, I'm not accepting any deal. We're going to have a motion to revoke probation. And that's where we're going to head. We can plead true or untrue, and the state will be obligated to present evidence, and the court will make its decision. Okay? Anything else?
That's it, Judge.
When can y'all be ready?
2 weeks.
You got it. 2 weeks. Good. Thank you. Yeah. That is all. See you in 2 weeks. Ooh, I guess he's got no bond right now, right? What's his
He does not have one set, but he is on deferred, Judge, so he is entitled to one if you would set one, please.
$1 million
That's fine, Judge.
plus GPS device
2 weeks.
plus home confinement? No. Let me ask you, hold on for just a second. Gone West, I've got Kizzy Landry and Kinsey Taylor.
Yes, Your Honor. Ms. Landry's one that you last week, let her continue on probation, her to get out to prove everything, but she's still being held by misdemeanor. So just years.
By what?
A misdemeanor.
Okay.
Yes, that has nothing to do with us.
Well, let me know when that happens.
Yeah, and I'm gonna check on it this week to see what's going on.
Taylor?
Quincy Taylor, we get about 4 more weeks.
It's just a plea.
I know, but he wants to think about it, or 3 weeks, wherever the court feels there's time to. I feel like it's going to plea.
Can we do it in 2 weeks?
2 weeks is not too bad.
All right. We said that 2 weeks. Thanks. Roger Carter? I thought that was Mr. Burbank. Is that the, am I the?
Thank Mr.
Roger Carter?
That's filed a motion to represent.
But it was. Was it? It's showing Mr. Burbank on the docket.
Always shows Mr. Burbank.
Kimler? Mr. Kimler? Petition for writ.
About that.
Okay. Who else? Who else?
I have one, Judge.
Where? I don't see it.
It's on the trial docket, but it's not a case set for trial.
Yeah, it somehow ended up on the trial docket for an
Where is it?
unknown reason.
Adria Richard, about halfway down on the trial docket.
Really?
It's right here. Yeah, we talked about it. I don't know how it ended up on the trial docket.
Well, what's this supposed to be?
Well, it's just a status review, Judge. She's on probation.
Oh, okay.
And so.
Is a probation officer here? Okay, it's a status conference on this?
It is.
That's you.
Wait, no.
Okay. 22-40703 is called the State of Texas versus Adria Marie Richards. That's you, ma'am? Mr. Galmore's here, and the probation officer is here. You were placed on probation last December, correct? 10 years deferred or unadjudicated probation. And there was restitution. Is this, I guess, what this is pretty much about?
Yes,
Trying
Judge.
to get the money back to the people who are the Port Arthur Community Federal Credit Union people, right? Where are we?
Well, Judge, I believe that everything is going well on probation. However, she had substantial periods of time of unemployment. She started.
Where is it? Where is it now?
She works at a school. What's the name of the school?
Yes, Prep. Yes, Prep Public School.
In
Where's that?
Houston.
Oh, in Houston.
Yeah. And so she believes that her first official paycheck, she'll be able to completely be current on all of her fees with probation.
But not completely pay it off.
Will not be able to completely pay it off.
Okay, with this financial situation now, what are you able to pay a month on this?
And it's 400
You're gonna be able to continue to do that?
and probably a little bit more if I can.
Well, all things being the same, I can't remember what the pre-sentence report was. Do you have a criminal history other than this? This is it?
It's good.
Well, this is the key. Get it paid back as soon as possible, all things being the same, and then it gets dismissed, which is the best outcome
Yes.
that's possible. But the people, they lose. And when it's a credit union like this, the depositors get hurt.
Right.
So there's a large amount of victimization here because everybody pays for increased costs to the bank that they have to pay for because of the loss. Well, that's hopefully inspires you to work real hard to pay it back as soon as possible. Okay. And probation, anything else?
No, sir. Just to reiterate what Mr. Galmore said, that she's doing well in all other areas. She has just some small arrears as a result of her unemployment at the beginning of the year. She has assured me that with the next check that she gets, she should be able to get current of the $1,500 that she's currently delinquent. So she is making monthly efforts. They're not quite meeting that $455, but I feel like she'll be able to get that all rectified.
That's important. So how much has been paid so far?
Towards restitution.
Yes, ma'am.
$1,445.
The total?
The total that she has paid and been credited is $2,305.
And the total loss again was
$45,368.97. I have a copy of her financial record if you'd like to see it.
Of course, if you pay $400 a month, we're talking about 100 months. That would take to pay that, which is 8 years. But okay, maybe something can be done to hasten this because it's good for everybody, including you, to do it. Okay, but let's review it in 6 months. Yes, is that you think? Okay, we'll review it in 6 months. Please get a resetting. Thank you, ma'am.
Thank you.
Yes.
Yeah.
Okay, thank you.
Tom, who do you have? What do you want?
I have Mr. Otno here. I was on the job.
It's a pretty nice.
Okay. Cedric.
Yes, sir. And afterward, we do have one family member that wants to allocate.
Okay.
I'll need to swear him in or fingerprint him.
Cedric.
This
That's
is
you?
Bob.
Yes, sir.
Mr. Right. You swear on. You've been nothing but the kind of stuff you got? Okay, you get to now first.
It's Roger Carter's on that's what. I don't know what the Roger Carter deal is all that.
There's a writ on that. And actually, there's, I'm going to see if he'll come back here.
Twenty-three CR 229 is now called the State of Texas versus Cedric Jerome Fontenot. That's you, sir?
Yes, sir.
Present with your attorney, Mr. Burbank, and the state's attorney. Does the defendant waive a formal reading of the indictment and the arraignment here? Can we proceed in summary?
He does in your mail, Your Honor.
In summary, this indictment alleges that on or about October 25th, 2022 in Jefferson County, Texas, you committed the second-degree felony of manslaughter by recklessly causing the death of an individual, namely Jonathan Allen Brody. Pick up the phone. God. The sign can't be any larger. Don't bring a phone. Everybody's got a phone, I know, but everybody turns it off like they should. And that's just ridiculous. We're at the bellow out like that. And it is further alleged in this very serious case that you operated a motor vehicle in an unsafe manner while using a cellular device and causing the motor vehicle to leave the road, cross over, and causing the motor vehicle to turn over and strike another motor vehicle operated by Mr. Drody. And thus, it is alleged that you used a deadly weapon, namely a motor vehicle, that was capable of causing serious bodily injury and death, and did cause that in the commission of this offense. Do you understand what you're charged with here, sir?
Yes, sir.
A second-degree felony means you face a term of not more than 20 years or less than 2 years in prison. In addition, a fine may be assessed not to exceed $10,000. Do you understand?
So,
an agreement has been reached where you would be pleading guilty, placed on deferred or unadjudicated probation, which can be up to 10 years in length. Fine $750. There will be other terms and conditions of probation which are normal and customary for this type of offense. Is that your understanding of the agreement?
yes, sir.
If I follow this agreement, sir, you have no right of appeal of your case. Do you understand?
Yes, sir.
How do you plead to this charge, this second-degree felony of manslaughter, guilty or not guilty?
Guilty.
Are you pleading guilty voluntarily, that is on your own free will, and because you are guilty.
Yes, sir.
Show you what's marked as State's Exhibit 1. Did you sign that document voluntarily?
Yes, sir.
Did you understand it? Discuss it with your attorney?
Yes, sir.
Is everything true and correct here?
Yes, sir.
State's Exhibit 1 is tendered into evidence.
No objections.
Without objection, it's admitted. Among other things, this states that you are mentally competent to enter your guilty plea. It is freely and voluntarily made. You know what you've been charged with. The indictment's been read to you. You've read it. You are guilty of this crime and any lesser included offenses. You have given up your rights to a jury trial and the rights to the appearance, confrontation, cross-examination of witnesses. You were totally satisfied with the representation provided by your lawyer. All of this is true. It states, so help you God.
Yes, sir.
State's Exhibit 1 is made a part of the record for all purposes. And again, pre-sentence report is here by way.
We do, the family's here, Judge, so we asked it to be.
Stand by. Is there a probable cause affidavit filed in this? I don't see it.
I didn't have one. I thought about it.
Don't know if there was one, Judge. Let me make sure. This was a great picture. Question, I don't know. You know, it's, usually is.
All right.
One second, Judge.
Anything else anybody wants to add?
No, Your Honor.
If not, if nothing,
Sorry for what's happened, Judge.
well, you can understand when somebody is injured, seriously injured, or a life is taken, you don't have the ability to bring it back. And a sorry doesn't bring back the life that the people want back. I'm looking at the information that I have in this case file, and it shows that since 2012, you have been convicted of over 20 motor vehicle violations. Speeding, no seatbelt, speeding, failing to drive in a single lane, speeding, no seatbelt, running a red light, no seatbelt, wrong color stoplight on your vehicle, no seatbelt, speeding equal to or greater than 10% above the posted, no seatbelt driving safety course. You've had at least 2 driving safety courses, I think, that you had to take, right?
Yes.
Failing to drive in a single lane. A non-injury accident in 2012. A non-injury crash in 2016. And then this in 2022. 20 violations. Now, this is what I've had my whole life. I mean, and I'm not special. It's not that hard to follow the rules. It's only a 4,000-pound missile that you're weaving through traffic in. A 4,000-pound missile, which has to be operated safely. So not only for yourself, but all the other people who rely on your safety. But over 20 years, since 2012, I mean, that's 13 years, 22. I'm just going to tell you, you look like, it appears here, you don't care about anybody else. Everybody else is just victim, a potential victim. My goodness, nobody in this room probably has that voluminous, irresponsible behavior shown in all these tickets, accidents, and then now someone's dead. You can add remorse to the equation all day long. You should have been sorry the first time you got a ticket in 2012. But you didn't, you've been making mistakes as quickly as anybody else, irresponsibly as anybody else I've ever seen in operating a motor vehicle, which means you don't care about others. That's not humane. That's not the way we all make it. We don't make a contract with each other, but it's kind of like that. We have a duty. Even though we sign a dotted line, we have a duty to safely operate 4,000-pound missiles so that others aren't put in harm's way, as well as yourself and your family, which you just seem to irresponsibly couldn't have cared for at all. You just didn't care. And here you are. And then you got grieving people who can't bring their loved one back. And too often these are called accidents, which minimizes the irresponsible behavior. This, you can call it an accident all day long, but this was inevitable. Someone was going to get seriously hurt or killed, if they hadn't already been, by your irresponsibility. So, there you are. Anything to add by anybody? Okay, I'm going to follow this agreement.
Yes, sir.
I'm going to find you have pleaded guilty voluntarily. You are mentally competent to do so. You understand and appreciate the consequences of pleading guilty.
Yes, sir.
There's sufficient evidence supporting your guilty plea from State's Exhibit 1 admitted here that finds you guilty beyond a reasonable doubt. But the agreement provides that you would not be found guilty. You may be placed on deferred or unadjudicated probation for up to 10 years, and it will be for 10 years. There will be terms and conditions of probation which are normal and customary for this type of irresponsible behavior, you're going to be required to take a safe driving program course and pass that. There will be other terms and conditions of probation that are, there are no less than 35 of them here. But a lot of these aren't going to be applicable exactly to you because of the nature of this offense, but most of them will. I'm not through. When you put our creators, humans, in harm's way irresponsibly like this, you pay a price. Somebody died as a condition of probation. I can sentence you to 6 months in the county jail, and I'm doing it. That's the most I can do. You think it's funny?
Yes, sir.
Of all of this, and you're going to grin at me?
That's smiling, sir.
You're going to think, you think this is, it's a grin. I know what a grin is. I'm old enough to know what a grin is. You think this is funny, sir?
I'm not grinning, sir.
It's a message. It's symbolic because we can't bring the life back. But you have been irresponsible for so long with a motor vehicle. It was inevitable. This was going to happen. And if you had had a clean record, and this isn't an accident. You tell you what you're indicted for, that you pleaded guilty to, recklessly causing the death of an individual. Recklessly. Which has its definition under the law. Get it word for word. Just, I see, all we do is deal with humans here, humans, and it has to be, you have to deal with them fairly and responsibly with the folks. But also, you can't hurt humans, and you can't put them in harm's way irresponsibly. A person acts recklessly or is reckless with respect to circumstances surrounding his conduct or a result of his conduct when he is aware of but consciously disregards a substantial and unjustifiable risk that the circumstances exist or the result will occur. The risk must be of such a nature and degree that its disregard constitutes a gross deviation from the standard of care that an ordinary person would exercise under all the circumstances as viewed from the actor's standpoint. That definition is not an award. That's a cruel, unthinking, unappreciative act toward others that you put in harm's way. And look, here it is. Somebody has died. What this court tries to do is be fair and impartial, but when the result is the death of a human, the court is going to set the standard I've always said, and the price is high when you are responsible for the loss of a human being's life. And you're going to jail for 6 months, and it will not just be punishment for you, but a symbol for others that they face 6 months in jail, which is hardly fair for the eternal loss of life. You didn't intend to do this. And I'm sure it's a terrible thing to have to deal with. But my goodness, why didn't you fix this 22 violations ago? We wouldn't be up here. Family all upset. You're upset. We're all upset. Nobody if we could have talked to you the moment before you got in that car and urged, something bad is going to happen down the road. Cedric, think about it. Be responsible, another human being or yourself. We're going to lose a human here. You'd have done, I think you would have tried to do something responsibly and been more careful. That's what, there are only limited things the court has the power of, and it's not to bring back life. Wish I did. Too often that sort of thing happens here. But the court can try to act responsibly in the determination of the punishment, and putting you on deferred probation is what most people get in here who haven't caused the death, much less even physical harm to others. They get deferred for nonviolent acts for the most part. But this has its place. And I've always thought the DA's office acts responsibly in what they do, and they know more about this than I do. But this court feels like with deferred probation, this condition of probation needs to be added, which is serious. And I don't know, I'll give you an option too. You can serve it on weekends, or you can serve it day for day. If you're going to serve 180 days, you get 3 days credit per weekend. You can do that 60 weekends.
You want to do that? Yes, sir.
Well, I can guarantee you that that's more punitive than day for day. That's what people say, but it gives you an opportunity to go out and work and try to pace.
Is that Friday at 6, Judge?
Yes, on or before 6:00 p.m. each Friday. And look, he's placed on probation, and the one thing that's not here is any restitution.
That was all worked out in a civil case, Judge.
Is that right? Is anybody from the victim's family here? I know financial is not what y'all are. But did you get fair recompense?
That was never mentioned to us. We didn't know.
Did,
Any kind of restitution from him, we didn't know nothing about. It was never mentioned to us.
no, but did,
His wife came in and talked to us before. He was married at the time, Judge. The wife came in, we dealt with all that. When I talked to her. Okay, you talk about his wife. Yeah. We have no dealings with her. I know that, but that was when it first came in. It was all that was through her. Okay.
hold on.
Are y'all have anything in pocket?
Or you don't know?
No, we're not out anything in pocket. We are not doing it.
Because I can hold that condition open for further information if you feel like it's necessary. But if
I would like that.
Because
they need to understand this is not for pain and suffering or anything like that. That's civil stuff. This is
that,
for stuff that's out of pocket or anything that costs people money.
Anything there, civil or anything, I think that's all been resolved.
Look, I'm not going to put y'all under the gun here on this. If I'm going to hold this open to consider restitution if information is received, because it seems like the surviving people here are just the surviving relatives. I don't think you're thinking about that right now. You're thinking about other things.
I don't mind, Judge, if you want to hold it open, but I'm
going to hold up to see, give them a little bit of time to make sure that there isn't a restitution issue. Because generally those things get resolved in the non-criminal end of things. People have insurance. Do you have insurance at the time, sir? You have insurance?
And you work for a company that who was on the job at the time, so that was dealt with then. And there was a letter sent out.
But I'm going to give y'all a few weeks to see if there's something that was not a T not crossed or an I not dotted.
Yes, sir.
Financially, so that the family can be recompensed properly, fairly.
Unfortunately, under the time that this accident occurred, the next of kin was his wife. And so we dealt with her.
Okay.
So
The wife was going to be the primary person who would be speaking for, but y'all let me know if there's something that was missed, please. And the court will do what it can under the law. When can you begin?
This Friday, good.
All right, so it will be on or before 6:00 p.m. each Friday, and then they release you Monday morning. And where are you working now, sir? You're not employed? No, sir.
He had home confinement. He does have a monitor which will be released and he'll be able to now go work. He lives home with his mom.
All right. This, when the loss of life is the subject matter, it's difficult for everybody. Is there something we're missing that we need to deal with?
One last thing, if we could sit over in the box right there, I believe someone wants to say something.
yeah, we do have an allocation we need to deal with, but there was no alcohol in the system at the time. If the judge is worried about that, it was just caffeine and stuff.
No, I was just,
But
if
there's
there's
nothing
any
else.
other reason that may have been the cause of this that I need to deal with.
No, Your Honor, there was a lot of factors.
All right.
We're not.
All right, then we're recess on that.
We do have the one allocation from brother, I believe, wants to speak on behalf of the family.
All right. Yes, sir. And just if you would be so kind to introduce yourself and how you're obviously a sibling.
Yeah,
of the deceased.
I'm the middle child. He was my little brother.
Yes, sir.
So we were best friends. We shared a room for 16 years together. So
Did y'all grow up in Groves?
we grew up in Binder.
Yes, because I knew the Drodies in Groves.
Do I start? Okay. I have it written down here. And when I showed this to my family, my brother, my parents, they said they didn't feel like anything else needed to be said. So we're in unity on this.
Right.
Jonathan, like I just said, he was my best friend, my little brother. No man knew me better than Jonathan, and no man ever will, because I can't go back and grow up with somebody again. With that being said, Cedric, I forgave you pretty quickly. I'm on the autism spectrum and I have a strong sense of justice. I need you to know that, because by my nature, it doesn't make much sense that I could forgive you so easily, especially given who Jonathan was to me. But I believe the fact that I feel the way about it is nothing short of a miracle from God. Before we learned about this plea deal, my family and I, we prayed for you in this situation. We didn't pray for punishment or for judgment. We prayed that whatever the outcome of this, that you would come to a place of repentance. And that's still my hope in all of this. You'll be on probation, can't come Sundays for a while, but I want you to know that if you need help staying on the right path, you can come to Eastgate Church where my wife and I attend, and we would welcome you, and you'd have an open invitation to sit with us anytime you wanted to. We do have church on Wednesdays, so you can make that. More than anything, we hope this is a wake-up call. That was what my mom really wanted to say. And we hope that you find peace in everything that happened and everything that you have to deal with. That's it.
All right. Anything else?
Okay. Does anybody else in the family do anything closer?
All right. We are in recess on that case then. Thank you. Anything else? Did you have another case, Tom?
I
And Roger Carter.
That's fine. That's not mine.
Oh, that's yours?
No, it's not yours. Write a direct letter.
Well, I know. I said, oh, he said it was his.
Yeah.
It's not mine. I'm gone.
Okay, Roger Malloy.
I already got this guy around.
Carter.
Time is jury coming back today?
About one. They start.
This one.
Okay, Roger Carter, please. Thank you. All right, we now call 25 CR 886, the state of Texas versus Roger Malloy Carter Sr. You're Mr. Carter?
That's, have a moment, Your Honor, he needs to sit. He is,
Okay.
I'll see with the judges.
Yeah, they can bring the wheelchair.
So you were here with your attorney, Mr. Kimmler. Anybody from the state here on this?
You were supposed to be my.
Yeah, he's probably talking about phone. Yeah.
I got it. I'll do it.
Okay, the stop is here on crash estate. Go ahead. There's a petition for writ of habeas corpus filed by the defense on September 8th of 2025. Go ahead.
Your Honor, for purposes of the record, I assume that the application for the writ has been granted in this hearing, so the term whether the relief requested therein should issue. Is that correct?
Yes.
Your Honor, bond currently is set at $1 million. This is a murder case. I'm prepared to offer testimony from Mr. Carter's wife regarding their financial circumstances, ties to the community, and safety of the community at this time.
Go ahead.
I'm going to call her as a witness. Yes, sir. Two first.
Go ahead.
Melissa Carter. This way, over here.
Okay.
Wow. Raise your right hand. Do you solemnly swear or affirm any statements you make during this hearing will be the truth, the whole truth, and nothing but the truth? So help you God.
Speak up.
Yes. Please tell us your full name and how you are related to any of the parties in this case.
I'm Melissa K. Carter, and Roger Carter, Marshall Lloyd Carter is my husband.
Okay, go ahead.
Ms. Carter, how long have you been married to Roger?
We've been married for 2 years, but we've been together for 42 years.
42 years. 2 years ago, you formalized that relationship through marriage. Is that right?
Yes.
Throughout that time, have you cohabitated with Roger Carter, lived with him?
Yeah.
Have you lived with him for the entire time?
Yes.
I understand he's charged with an offensive murder. Is that correct?
Yes.
And his bond currently is set at $1 million. Is that right?
Yes.
In connection with that, did I ask you to get some information from 3 different bonding companies?
Yes.
Regarding how much they would charge you and other conditions that they would require to post a bond in the amount of $1 million?
Yes.
Did you contact those bonding companies?
Yes.
Which 3 bonding companies did you contact?
Allied, Reed, and Bell American Backbone.
And what did each of those 3 companies tell you regarding what they would require to
post a $1 million bond?
Allied and Bell American, they don't use collateral. Each one of them said that with the $1 million, it would be $1,000 down, or it could be 75,000 with a good cosigner.
How much down?
75,000 with a good cosigner. With just the $1 million bond is $100,000. The $100,000 bond would be 10,000 down. They're not taking.
All right, let's do that in a minute. We'll start with the $1 million bond.
Okay.
What did each of the bonding companies tell you regarding the $1 million bond? Start with Allied.
Allied, he had to have a good cosigner. Al Reed.
How much did they require down?
$100,000 down.
And a cosigner.
The cosigner 75,000 down.
With the cosigner 75,000?
Yes.
Okay. And they would finance the 25,000?
Yes.
All right. What about Al Reed?
Al Reed, no quote given for the 500,000 or the $1 million.
We're just doing the middle. So they wouldn't even give you.
I'm sorry.
They wouldn't even give you a quote for $1 million?
Because they said that the conditions would be too strict, and they didn't want to put, be up under that kind.
They weren't even willing to write it on.
No.
What about the last one? Did you say Bail America?
Yeah, and they don't do collateral, and you must have multiple cosigners.
How much did Bail America require down?
It required the $100,000 down for the $1 million fund.
And multiple cosigners.
And multiple good cosigners.
So they were not willing to finance the down payment of $100,000.
Yeah.
What about the $500,000 bond? Same question for each of the bonds.
Well, Allied said $50,000, and it was still with a good cosigner. Al Reed, they did kind of. No, they don't want anything to do with that. The $500,000 or the $100,000 because it had to be evaluated under strict conditions.
What about Bail America?
Bail America, they said $50,000, and they didn't say anything. They said that they don't use cosigners. I mean, not collateral. All they use is cosigners.
But they wanted $50,000 down.
Yeah.
Last question. What was the amount of the bond? The last question that I asked you to check for.
The $100,000.
$100,000 bond. What did Allied tell you about a $100,000?
$10,000 down with a cosigner.
And they weren't willing to finance the $10,000. It was up front. Is that right?
Mm-hmm.
Answer yes or no.
Yes.
What about Al Reed on a $100,000 bond?
Al Reed said that they would do between $10,000 and $15.
15 what? 15?
10,000. I'm saying it backwards. $10,000 with a good cosigner. But at Al Reed, she said that if it can get down to $100,000, she said that if I'm not in a state where I couldn't pay it, and I'm not in that state, I am in it. She would try to work with us.
Oh, the amount of the down payment.
Yeah.
All right. Did she say how much of the 10,000 you could put down and how much you could finance?
No, she told me to call her when we.
If the bond is full.
Yeah.
What about Bail America? What did they tell you about $100,000 bond?
The same thing, $10,000, but I still had to have a good cosigner.
And as far as the 10,000, were they willing to allow you to finance that, put some down and pay for it?
They wanted the whole $10,000 and had the cosigner.
Yeah. All right. What is your financial condition right now? This is, I want to know savings, checking, real estate, stocks, bonds, vehicles, whatever you've got, liquid assets.
Have any vehicles? I don't
know what you don't have. What do you have?
Nothing.
And do you rent or own your own house?
Rent.
Do you own your own car?
No.
Do you have a vehicle? Do you own a vehicle? Do you have, how much money do you have in your bank account?
Negative $550 something.
And anything else of value that you have? You have like a rare stamp collection or any kind of anything you can turn into money. Anything you can take to a pawn shop and get money for. Generator, chainsaws, anything like that you could turn into money. How long
Has Roger lived in Jefferson County?
All his life, he was born here.
And where do you all live?
Okay. On 13th Street, 46, 47, 13th Street in Port Arthur.
Port Arthur, Texas. And how long have you been at that address?
For 24 years.
So he's lived at the same address for 24 years?
Yes.
And is he employed or what does he do?
He's disabled.
What other ties to the community does Roger have, to your knowledge? Does he go to church here? Does he have family here? Does he have
family?
What family?
He attend church from time to time.
What church you attend?
That's I had a stroke. I gotta get. Mount Calvary. Mount Calvary. I just drive to it. I don't.
Yes, ma'am. What about as far as other family members here?
He has 2 sisters and a brother that's still living. Everybody else is deceased.
As far as his medical condition, what's your knowledge about his medical condition?
He has COPD, streaking in the lung from asbestos. He has ulcer on his left great toe that has not healed. It healed a little bit, but it keep bursting back open. And he has an infection in the bone of that toe.
What else? Okay, keep going.
He has
high blood pressure,
diabetes. He has kidney problems.
Best vision.
He has glaucoma.
Pretty bad shape, would you agree? What's the name of his home health provider? Amy
Campbell.
Amy Campbell. Now, I represent to you, I've spoken to Ms. Campbell, who wanted to be here, but was advised by their lawyers that HIPAA would preclude her from testifying. But she's his home health nurse, is that right?
Yes.
Are you aware that, how long has he been in jail?
Since the 7th of July.
And during his jail time, was he hospitalized?
Yes.
How long was he in the hospital from the jail? Was he transported to the hospital from the jail?
I know he spent a little over a week one time. And the other time that I know of, he spent like a few days in there.
The jail would have those records when he was actually in the hospital?
Yes.
If he's released, if you post a bond and he's home, would you make sure that he gets his medical care and he attends all his court dates?
Yes.
You vigorously contest the allegations that he's not guilty of this murder. We want a trial. Is that right?
Yes.
How fast witness?
Were you there during the murder?
No.
Okay. So if there was somebody that was there and that saw your husband or another individual get out with the victim in this case, they heard multiple gunshots and only the 2 of them got back in the truck and drove. He was there, wasn't he?
She doesn't. I would object. That's beyond her knowledge. I was asking.
Hold on.
Hold on.
Hold on.
Vigorously contest your honor. He was there.
Overruled. He has a right to cross-examine and she can answer. You don't answer
I'm
for
not
her.
presenting her as a fact witness.
Sir, once again, you may be quiet while he speaks and don't speak over that person. You put her on. He is now going to cross-examine her.
And I would
Thank you,
object that
sir.
it goes beyond the scope of this hearing.
Overruled. The facts of cases.
She's not a fact witness. She's not being presented as a fact.
He's asking her if she is or not, unless you were there,
I'm
sir.
not presenting her as a
Sir,
fact witness.
are you going to argue with the court? I've already made my ruling. Overruled. Ask your next question. Thank you.
So you weren't there to see anything, were you?
No, I wasn't.
So the probable cause affidavit that's filled out by an officer who talked to the fact witnesses would be more apt to talk about the facts than you, wouldn't they? They'd be better. Okay. So if the fact situation says that your husband was there and that he was the one shooting because of the circumstances, you wouldn't be able to dispute that just from the facts, just by what you feel, right?
I don't know the facts, but I know how my husband is. I've been with him 42 years. He won't harm nobody.
From what I hear, well, he's got several assault cases that he's been arrested for, hasn't he, over the years?
Must have been when he was a teenager because he don't do anything.
So,
hold on. I'm going to clear the record up here. I don't see this in the public safety report or any other record.
There's no convictions. There's several arrests, though, Judge, at least what I see.
Presumption of innocence is the standard.
Say it, Judge.
Okay. I won't consider it unless y'all got evidence that supports it.
So what I'm hearing though, and I just walked in the middle of the hearing because I was outside the hallway, but you don't seem to have any resources to make a bond, do you?
No, actually I don't, but I can call family members if he get it low enough where he can. I'll try some kind of something to help him because he's sickly.
But you don't know what that is that you can get from the family members.
No, I don't.
Have you tried calling them about this bond?
Yes.
Okay. And they've all said, no, they can't help us.
Who can't pay $1 million bond?
I didn't ask that, ma'am. I asked, did they say they couldn't help you?
No, they can't.
Okay. So have you asked them what they could afford to help you with?
No, that's why we're here, so I could find out if it'd be lower.
So you haven't determined what amount your family members or friends could give you, is that right? Okay. I'll pass what it's true.
Let me ask, can you elaborate a little bit about his health?
Rob, he would be in a better position to do that, Your Honor. I think I would present him for the limited purpose of testifying about his health. I did want to get his healthcare provider. I spoke to her on the phone, but HIPAA prevents her from testifying, is what she said. She consulted their attorneys. So she can't.
Go ahead.
What's your health condition? Well, what is it specifically?
I have asthma, COPD. I used to work construction. And I have asbestos in my left lung. I was working in Mobile here in Beaumont. I fell 30 feet off of the scaffold. I messed my back up, my back and my neck. I have chronic pain.
Why were you hospitalized?
Because my blood pressure, it fluctuated on them, and it was like 120 over 135 over 120. It was real high. And then the second time it was lower.
Yeah. What we do want to get accuracy, you're going to have I want to know what you may have to say. How are we doing?